And just so you both know, you guys weren't being recorded. I had it muted, so.
All right, thanks. Yeah, I think you were muted when I asked, and I was like,
Was, yeah. And you can't see my face. I'm like, yes. There we go. All right. Here comes Alyssa, Michael Drysdale, and John Polis.
Good morning.
Good morning.
We'll get started here in just a few minutes, or maybe 2 minutes. Everyone gets on here.
We might need to wait a couple minutes. Jeff Fugate's having some computer issues, and he's part of this first hearing. So if we can wait a second until he shows up, please.
Fair enough. Thank you.
Thank you.
Now,
Yep.
now it's Karen here. Is John going to be able to join us today?
Yeah, I see him. He's over there.
Oh, good. I'm just sure, you know, he was having so much trouble with his eyes yesterday. I just wondered.
Yeah, we
Good.
have John and Tim and me and you.
Good. Okay.
Thanks, Karen.
Thank you.
Jim, are you and Jeff communicating somehow to kind of see what his status is?
Yeah, he was just in the room here. He left for a second to see if he could log on. If not, we'll try to figure out some other way to do this.
Okay.
I have a second computer here he could probably use. So if you bear with me, I'll actually go run over there. He's just a couple offices away. I'll see what the deal is.
Yeah, it's fine. Just so that somebody kind of knows if he's doing okay or not doing okay.
Yeah. You had
Thanks.
a long day today. I'm sure you're ready to get rolling today. Or long day yesterday. So
Yeah, it's fine, but we need him, so we'll wait.
sorry. Thanks.
Yep. Give me 1 minute. I'm gonna go remind my dogs that not everyone needs to listen to them. So just 1 second. All right, doesn't look like we got him yet.
It looks like I see a second start computer there.
Oh yeah, there you go.
And there's Jeff. All right, we should be good.
There he is. Hi, Jeff. Okay, so we will call to order the July 23rd Mine Land Reclamation Board meeting. My name is Nell Wareham. It looks like we have 3 other board members with us today: Karen Utterback Norman, John Singletary, and Tim Mock. We're going to be on item number 7 on the agenda. I think there's a couple of things here where we've got a housekeeping matter for a ProHack representation that we probably need or will need a motion on. And then after that, Jeff, I may just ask you, and we can discuss if we've done any allocation of time with folks. And then we might just discuss a couple other matters before we get right into the meat of this here. So item number 7 is the application for Mr. Timmons to represent. Chuck, I don't know if you want to weigh in on thoughts on that.
Yeah, so for the board members, just want to give you some background. So Mr. Timmons is an out-of-state, licensed out to practice out of state. And in order to appear before the board and represent his clients, there's what's called a ProHack Vici application. The Colorado Rules of Civil Procedure have a kind of a checklist of things that someone is supposed to do if they're requesting to basically appear in a proceeding in Colorado when they're not licensed to practice law here. I took a look, and it looks like Mr. Timmons has kind of checked those boxes. There's we got an application, or he has to apply to the Supreme Court. They kind of run for lack of a better word, a background check, and that came back fine. And so the way it works is that even though the Colorado Supreme Court has, approved this. It's still up to the discretion of the board as to whether or not they allow Mr. Timmons to appear and before the board and represent his clients. So, for your edification, he appears to have complied with the rules, and I don't know if there are oppositions to him appearing, but it's certainly up to the board to approve that, and it's at your discretion. So,
Great, thank you. Are there questions about that process or concerns from anyone? Discussion? I'm not seeing any questions. In this case, this is something we feel like we should make a motion on. If anyone could entertain a motion.
I'll go ahead. It is moved that the board accepts Mr. Timmons to represent his clients here in Colorado for this meeting on the 23rd of July, 2020. Is that sufficient, or do we need to be in more detail?
I think that's great. Thank you, Karen.
Tim Mock will second.
Thanks, Tim. Discussion? Okay, all those in favor, please signify by saying aye.
Aye.
Aye. Those opposed, same sign. Is that you saying, John? You're muted, John.
Let me see if I can help him here.
There you go.
Okay, there you go.
Yeah, no, I actually made a motion first, but that's, so I'm in favor of it. That's
Okay,
fine.
thank you. A silent motion. Okay, so the motion passes. Thank you, Karen, for that discussion. One more thing while we're in that, I believe, Jeff, there was has there been discussion? I know that there was a request for party status by the environmental groups. Is that something, where did we land on that proceeding?
Yes. Oh, mute your, sorry, we'll mute some speakers here. You have to turn your speakers down. There we go. Okay. Sorry about that word. Please bear with us here. Everybody else have their microphones off? Okay, it's coming from your computer.
Somebody's got it on.
Okay, I think we got it. Sorry, we're sharing a conference space here and we're trying to battle the echoes. Jeff Fugate here on behalf of the division. I've not had conversations with the parties about the request for intervention or party status. So I defer to Mr. Timmons and Mr. Drysdale on that. I don't know if it's opposed or not. And then to follow up or circle back on your question about timing and allocation of time, we did not discuss that as well. We do have a suggested order, but we have not discussed kind of the timeline or the time limits on this hearing.
Okay. So regarding the party status, Mr. Timmons, and was there any discussion or concern here?
This is Mr. Timmons on behalf of the conservation groups. I have not had a chance to speak with Mr. Drysdale regarding this. I mean, I think the essentially the question is are we adversely affected by the potential decision of this board here? I think that all the conservation groups have been involved with proceedings and litigation regarding the West Elk Mine for years. Our standing has been upheld in federal court on multiple occasions. I think this is probably pretty straightforward. I'm happy to talk more if Mr. Drysdale would like, but if it's opposed, but otherwise I think think we can probably hopefully make this pretty quick.
Okay. Mr. Drysdale, did you have any concern or comment?
The only thing that I would raise is that it relates to the specific nature of the cessation order at issue. I certainly don't have any issue with regarding, them on their appeal of a minor revision 446. But, as I'll explain in my presentation, what they are saying is that, and what the division has stated in its order, is that we lack a legal right of entry. And that's really a matter between the lessor and the lessee. I don't really have a problem with them presenting and making their arguments at this case, but I would like to reserve that concern that it's not clear to me they're attempting to assert the rights of others. That's third party standing. And at least in a judicial context, there's significantly greater restrictions on that. Again, I don't want to hold up the presentation, but I just wanted to note that for the record.
Okay, thank you. Any other commentary, comfort here? Chuck, any thoughts? We okay? Okay. So Jeff, you hadn't allocated specific time, but you had an order.
Again, that's correct, Jeff Hugate for the division. Kind of the suggested order, I think, would follow what the board traditionally does in contested matters or appeals. Division starting off with initial kind of introduction, presentation. And then it's really a question for Mr. Drysdale if he'd like to present second or third. And I think we could follow that order for rebuttal. And then again, short closings for all parties. So that would be my suggested order.
Sure. So Mr. Drysdale, would you like to follow the division or follow the operator, the intervener?
What I would like to do, if it's acceptable, is follow the division
Okay.
and then reserve a little bit of time to respond to the intervener once they're done.
In a rebuttal statement or?
Yes, responding to certain things that they have argued.
Sure. So what we'll do is everyone will get some time for an intro and presentation. Everyone will get an opportunity for a rebuttal, and everyone will get an opportunity for a short closing. Fair? Okay. All right. We got all that taken care of. Well, with that, I think we'll let the division begin its presentation of item number 7, Mountain Coal Company, regarding a formal public hearing on cessation order CO-2020-001.
Sorry, I'm trying to share my screen here, sorry. No. Okay, sorry about that. I should have brought my 13-year-old son to help me with this. So we are here today to have a formal public hearing for the West Elk Mine, file number C-1980-007. And what we're discussing is cessation order CO-2020-001. And my name is Jim Stark, and I work for the coal program. So I'm just going to give a little background, kind of a factual background on the cessation order and just a brief bit of history on the litigation. I'm sure the other two parties are going to go into that a little bit deeper, but just a brief history for everybody. So the West Elk Mine is located about 8 to 10 miles east of Paonia. It's that little pink area right there. That's the mine permit. A little bit more blown up, the permit area encompasses, it encompasses approximately 20,000 acres with 16,000 affected acres and approximately 600 disturbed acres. So some of the background, the area in question was permitted with permit revision 15, and that was approved by the division in September of 2018. We had a formal public hearing on PR 15 in October of 2018. The division's decision became final upon the board issuing an order to make the decision final in November of 2018. So this area is sometimes known as the Sunset Trail area, the Sunset Trail mining area. So again, this has been the subject, the Sunset Trail area and the roadless area has been the subject of a decade or more of ongoing litigation. Initially, the Colorado roadless rule went into effect in 2012, and it included what was called the North Fork exception. And it was 3 areas in the Colorado roadless area that allowed for development, and specifically allowing for development for coal mining. And one of those areas was the Sunset area, which is where the West Elk Mine is currently mining. The North Fork exception was vacated in 2014 due to a NEPA violation. Subsequently, the Forest Service went back, did some supplemental NEPA work, and readopted the roadless rule in 2016. Again, there was more litigation, and the North Fork exception was vacated again in 2020, so just this year. So briefly, this is a mine plan map that was approved with PR 15. You can see the longwall panels, the 4 longwall panels, and then the roads and drill pads for mine ventilation boreholes as originally permitted. And again, there are 4 pads, and I want to say there were about 40 to 50, 4 panels, sorry, and about 40 to 50 ventilation boreholes permitted at that point in time. There have been subsequent revisions to that permit, which changed the location of the roads and the pads. And that's typical. You know, the operator comes in with a plan initially, they get on the ground with Forest Service, who's the land manager in the area, and they realize that, you know, they need to move the holes and move the pads for whatever, or the roads, the pads for whatever reason. So there have been 3 separate revisions that have changed those alignments. So a little bit more on the North Fork exception. In March 2nd of 2020, the 10th Circuit Court of Appeals remanded to the District Court of Colorado and ordered that the North Fork exception be vacated. On June 15th, 2020, the District Court of Colorado vacated the North Fork exception. So that's when it kind of became officially vacated. So some background on the cessation order. In the first week of June, West Elk constructed roads and drill pads in the Sunset Roadless area for their second panel. And that was in the North Fork exclusion area, and that was prior to the vacation by the courts of the North Fork exception. On June 10th, the division conducted an aerial inspection and confirmed that in fact these roads and a couple of pads had been constructed. And then in June 11th of 2020, various conservation groups requested that the division inspect the Sunset Roadless area, and in particular this area where the new pads and roads had been constructed on panel 2. So on June 15th, the district court vacated the North Fork exception, as I previously said. On June 18th, the division issued cessation order 2020-001. Also on June 18th, the division, based on the June 11th request from conservation groups, the division conducted an inspection of this Sunset area and the panel 2 area with conservation groups. And again, it was what we had seen in the aerial photography. They had built a couple of road segments and a couple of pads. On July 2nd, Mountain Coal requested a formal public hearing, and that's why we're here. So what does CO 2020-001 entail? It was issued for a failure to maintain valid right of entry for the Sunset Roadless area. And in issuing this CO, the division determined that the condition or practice is causing or can reasonably expected to cause significant imminent environmental harm. The abatement for the CO was to provide the division detailed information regarding the right of entry in light of the vacation of the North Fork exemption. So understanding, the division's thought was understanding the fact that there's a lease in place. The court is saying that there is no more North Fork exception. So we were asking the operator to provide detailed information on why they think that they can go into the roadless area and construct roads. And that's the end of my, just kind of my information. I'm going to go to my presentation now, if you can bear with me for a second here. And if there are any questions on any of that, I can answer those if the board has any questions. All right, fantastic. So, sorry, did somebody have something? Okay, so this is the division's presentation on CO 2020-001 for the West Elk Mine. Again, the division issued the cessation order on June 18th, 2020, and it was issued for failure to maintain legal right of entry. And again, the division understood that West Elk and Mountain Coal has leases with BLM, and those leases contain a surface use agreement with the Forest Service. The issue at hand, however, was the vacation of the North Fork exception by the District Court of Colorado, and the fact that they basically said that this is now a roadless area. So the division felt that they no longer had right of entry in light of the court decision. This is a quick aerial of one of the road segments that was constructed in the Sunset area that's in panel 2. Typical road construction, they cut down the trees, they basically windrow the topsoil and create a road. I mean, nothing atypical out there. This is just overlaying on the map that shows what they have done at this point. Again, a picture of a drill pad with a part of a road segment, nothing atypical here. This is typical road and pad construction. I mean, we're not saying, I mean, West Elk does, in our book, does great work out there. We're not questioning the work that they did. We're questioning the fact that we don't believe they can do any further work out there. So what is CO 2020-001? It prohibits further ground disturbing activities in the Sunset Roadless area. That applies to all 4 longwall panels, panels 1 through 4. Ground disturbing activities includes tree cutting, road construction, drill pad construction, drilling of mine ventilation boreholes, anything out there that's going to further disturb the ground in the Sunset Roadless area. The CO also required the removal of all equipment from longwall panel SS2, SS3, and SS4 areas. And when we were out on site, all of the equipment had been removed already. Weston Norris, the mine manager, had said that they moved it the night before. I'd given him kind of a heads up that we were issuing this CO the night before we issued it. So he had everything removed by the time we were out there the next morning. So that's not an issue. He also said that they were going to put up a gate out there to block off the area so nobody goes down there accidentally. Not part of the CO, but something that they were going to do. So this CO, it does not allow for any activity that was approved with PR 15 or subsequent revisions in the Sunset Roadless area. So back in the original, I showed where the roads and pads were going to be with the original PR-15 submittal and then 3 subsequent minor revisions. All of that work, even though it's approved, it's on hold because of the cessation order. So West Elk cannot go in and do any further activity in this roadless area. And again, the division determined that a condition of significant imminent environmental harm exists out there. Really, given the fact that the NFE was vacated, the North Fork exception was vacated, this is now a roadless area. So any further work out there can't be undone. So any work that's done will cause significant environmental harm to this roadless area. Again, in the CO, we do allow for continued mining activity in panel SS1. I can also add to that any development activity in any of the other panels, SS2, SS3, SS4. This has nothing to do with any of the underground activity. This also allows surface access to longwall panel SS1 areas. So there are roads and pads and mine ventilation boreholes that were previously constructed and drilled last summer. Those are not at issue with this CO. Again, they can't do any further ground disturbing activities in panel 1, but everything that's there in panel 1, they can access. It also allows for maintenance and ground stabilization activities to prevent offsite impacts. So, they get a big rainstorm and they have a problem, they can go in and do what would amount to minimal ground disturbing activities to shore those areas up. So that's maintenance and ground stabilization is a little different than construction activities, and those are allowed activities. So we haven't shut the mine down, we've just stopped further construction work on the surface at this point. So the abatement for the CO, and I'm going to read that, if you can bear with me. I don't generally like to read things into the record, but I think that it bears actually reading that. The abatement is, notwithstanding BLM leases C 1362 and COC 67232, Mountain Coal must provide the division with detailed information regarding its assertion that it maintains legal right of entry to the Sunset Roadless area and why it is not in direct conflict with the district court order vacating the North Fork exception to the Colorado Roadless rule. So again, understanding that they have a valid lease in place, we believe that the vacation of the North Fork exemption to the Colorado Roadless rule takes away their legal right of entry. So the division's authority to issue the cessation order. And again, I apologize, but I think we need to read this entire part of the statute. So 3433, 123, parent 1, parent A states, when on the basis of any inspection, an authorized representative of the office determines that any condition or practice exists at a surface coal mining operation which is subject to this article, or that any operator is in violation of any requirement of this article or any permit condition required by this article, which condition, practice, or violation also creates an imminent danger to the health or safety of the public, or is causing or can reasonably be expected to cause significant imminent environmental harm to land, air, or water resources, such authorized representative shall immediately order a cessation of surface coal mining and reclamation operations, or that portion thereof relevant to the condition, practice, or violation. And again, as I stated, this is now a roadless area based on the vacation of the North Fork exception. The imminent environmental harm that would be caused is creating new roads in a roadless area. That and the lack of right of entry is why the division issued the CO. Again, rule 5.03.2, parent 1, parent A, it basically mirrors that section of the statute. And I'm not going to read that. It's basically the same verbiage. Further, based on right of entry, 3433.110, parent 2, parent J, requires a statement of documents upon which the applicant bases such legal right to enter and commence surface coal mining operations on the area affected, and whether that right is the subject of pending court litigation. Again, based on the litigation, we don't believe that the operator maintains right of entry at this point. And again, Rule 2.03.6 basically mirrors the statute. One of the concerns raised by the operators is the division's authority. I think our authority under the rules is clear. Our authority to issue the cessation order is clear. The other issue is whether we have the authority to issue the cessation order under our cooperative agreement with the Office of Surface Mining. So I'm going to digress for a second and just give you I don't know, 3 or 4 minute primer on the coal program and how it operates, because it is quite a bit different than the minerals program, which you're used to working with. On August 3rd, 1977, Congress enacted the Surface Mining Control and Reclamation Act, SMCRA. That act allowed states to gain primacy if they had a similar act and similar rules. So in December of 1980, Colorado gained primacy. And again, this is a prime example of cooperative federalism. So Colorado was basically given authority over all permitting, inspecting, and enforcement activities at coal mines in the state. This has a cooperative agreement. So this primacy has a cooperative agreement, and it's in 30 CFR Chapter 7, Subchapter T, Part 906. And basically that lays out the different roles for the Department of Interior / Office of Surface Mining and the Division of Reclamation, Mining, and Safety. It says what each party's roles are. So if you look at the cooperative agreement, paragraph 18 in Article 7 says DRMS shall have primary responsibility for enforcement procedures, including issuance of orders of cessation. Division's sole responsibility. Now, Article 7, paragraph 17, the one before that, says enforcement authority given to the secretary under other federal laws is reserved to the secretary. Division's not questioning the validity of the lease, which would be under the Mineral Leasing Act. The division is questioning the validity of their right of entry based on the district court vacating the North Fork exception. And that is expressly reserved to the state. That is something in our act and in our rules. Right of entry is expressly reserved to the state. So that's where we're going with right of entry here. On a little bit different note, this is in Appendix B of the same cooperative agreement. It's talking about the division will reserve the right to modify the permit or permit revisions when appropriate in order to resolve conflicts between the permit requirements and the requirements of other laws, rules, and regulations administered by the secretary, and that's the Secretary of Interior. Again, right of entry is solely within the division's purview. The division has the legal authority to question right of entry and to write cessation orders based on lack of right of entry, based on both our statute, our rules, and our cooperative agreement with the Office of Surface Mining. And again, we're resolving a conflict based on 3433 110 2J and Rule 2.03.6. And again, this issuance of the cessation order didn't just happen in a vacuum. We did discuss the current operations at the West Elk Mine with the operator. We were in discussions with BLM and the U.S. Forest Service prior to issuing the cessation order. Forest Service and BLM were pretty mute on what they were going to do and what their thoughts were, probably due to the ongoing litigation. The operator indicated that they were going to continue road and pad construction. Again, that's part of what precipitated the division's decision that there was imminent environmental harm and that we needed to stop this, given the fact that this is now a roadless area. Regarding the cooperative federalism, kind of the cooperative agreement with the federal government, we also had discussions with OSM staff after the cessation order was issued. On that call was the Western Regional Director, the head of the Denver Field Division, that's kind of our oversight branch, the head of the Program Support Division, they're the ones who do the coordination with other federal agencies, and they also had their solicitor on the phone, and their solicitor was actually the one who was involved in the litigation with BLM and the environmental groups. At no point in time did any of them raise the issue that we were overstepping our bounds, that we were outside of what we were allowed to do within SMCRA, within the Cooperative Agreement, within the Colorado Coal Regulations. So I believe that that's a non-issue at this point. So what the division is doing is we're simply asking the board to uphold cessation order CO 2020-001. And with that, I will stop sharing my screen if I can figure out how to do that. And I will open it up to any questions that the board may have. Oh, sorry, did somebody say something?
I'm not seeing any questions.
Okay, no questions. Okay, thank you.
Okay, so now a presentation by the operator, introduction and presentation, Mr. Drysdale.
Certainly. Now I'm going to also try to share my screen, and hopefully that will go successfully. Give me a moment. All right, can folks see this okay? Neil, can you see this?
Yep.
Okay, good. All right, so my name is Mike Drysdale. I am outside counsel for the West Elk Mine and Mountain Coal Company, which is a division of, or is a subsidiary of Arch Coal Company. I will be providing this presentation to the board this morning. I also have listening in a couple of staff with Mountain Coal Company who are there to provide testimony and or answer questions to the extent that you want to hear directly, anybody wants to hear directly from mine personnel. The people who are available are John Polos, who's the manager of engineering and environmental affairs at West Elk. And in the same office with him and on the same link is Kathy Welt, who is an environmental engineer 3 at West Elk.
Mr.
So-
Drysdale, sorry. We got so tied up in the housekeeping and the timing and stuff. This is my fault. I forgot to swear everyone in. This is what
Oh.
happens when we're
Yes.
we're all on Zoom and we're not in the courtroom. So if everyone, including Mr. Stark and those from the division, I truly apologize. If we could just all swear to tell the truth. If you plan to testify, we'll just do everyone at once, including the environmental parties. So just, I will trust that if I say, does everyone swear to tell the truth, that you will?
I will.
Will.
Thank you guys. Sorry about that. Okay, Mr. Drysdale, please continue.
Okay, so so I'm going to walk through some of the background on this. Some of this Mr. Stark ably covered. There are some additional facts and some significant differences of opinion on some issues here. So I'm going to start a little bit of, here's sort of a roadmap for what I'm going to cover. How we got here. A lot of that I'll be able to go through more quickly because Mr. Stark covered some of it. Secondly, the jurisdiction of the division and the board. Here, I do depart from Mr. Stark and the division. We believe that this cessation order exceeds the state's authority. I will then talk about why Mountain Coal's past and planned future work is lawful. This addresses the issue of showing why we are allowed to do we were allowed and are allowed to do road pad drill work under the Colorado Roadless Rule. I'll discuss our specific request for the boards, and then we'll talk a little bit about next steps. So with that, a little bit of additional background. West Elk Mine was opened in 1982. As I think Mr. Stark intimated, we really have an outstanding compliance record. There have been no prior cessation orders during the entirety of Arch Coal's ownership. Arch Coal acquired the company, I believe, in 1998. There have been no NOVs during Arch Coal's ownership. We have received multiple reclamation and safety awards. This is an operation that prides itself and works very hard to comply with the law at all times. The mine presently employs 300+ people. We're the last remaining operating mine in the North Fork Valley. The surface is a mix of private lands and GMUG National Forest, United States Forest Service lands. That distinction becomes pretty important to the issues we're dealing with in this cessation order. The coal that we are mining is a mix of fee and federal coal. All the issues that we're dealing with here relate to federal coal under federal surface because it's a federal rule that applies only to that part of the operation. Now we mine coal by longwall mining underground. In general, North Fork mines are considered gassy. That means that they release a fair amount of methane. That methane has to be ventilated for safety. And that requires the use of methane ventilation boreholes drilled from the surface, as we've been doing for years. And here's one point I want to make really clear, because this will become important to our rights going forward. Mr. Stark pointed out that the cessation order doesn't prohibit anything going on underground. It just prohibits activities on the surface. But as a practical matter, that prohibits mining. I'll talk a little bit more about that because we cannot safely mine this coal without ventilating methane through surface features, the MVBs. Now, methane ventilation borehole construction requires a few things. Because this is roadless, it requires temporary roads to access the drill sites. For each drill site, for each MVB, approximately a half-acre pad is required to accommodate the drill rig. You saw examples of that, of those pads in Mr. Stark's presentation. And then the MVBs themselves are spaced every few hundred yards above the longwall panel to allow a means for the methane to escape. Now, I'm going to just go through this very briefly because Mr. Stark covered much of it. This is the history of the roadless rule, very complicated, very long, really begins back in 2001 with the Clinton era roadless rule. And I don't need to cover it because Mr. Stark covered the other parts of that. I would want to point out that the Colorado roadless rule reflected many Colorado specific improvements to the national rule. They are fixed errors in the maps. They expanded the surface protections on hundreds of thousands of acres that include withdrawing many of those acres from mining. And they also created this North Fork exception that Mr. Stark talked about, which allows road building for coal exploration and development in about 20,000 acres of the North Fork Valley. This is a federal rule applicable only to federal lands. And it is the existence of the North Fork exception that allowed the Forest Service and BLM, the BLM with the Forest Service's consent, to approve lease modifications under the Sunset Roadless area. Now, as Mr. Stark relayed, the conservation groups have challenged this from inception. And the part I want to focus on is the last go round in 2017, when the repromulgated North Fork exception and the lease modifications were reissued. The federal district court in that case upheld all those decisions, and mining commenced in the Sunset Roadless area. The conservation groups appealed. They did not appeal all the rulings of the district court. They did not appeal the consent of the Forest Service to use and occupancy of the surface. They appealed the exception, and they appealed the lease modifications on a specific grounds related to methane flaring that is not an issue in this cessation order. Now, we talk about so the 10th Circuit decision, as of spring, we had mined about a third of the first Sunset longwall panel. We were preparing for transition to panel 2 in the fall of this year. So a lot of the underground work, the development work, was well underway. And that, of necessity, required new pads, new roads, and MVBs to be constructed this summer, this construction season. In March 2020, the 10th Circuit decision was issued. That, as Mr. Stark indicated, invalidated the North Fork exception. But it also affirmed the lease modifications. And as Mr. Stark indicated, there's no question that those leases are valid. Now, the plaintiffs in some of their submissions have made some arguments about how, well, it didn't really affirm the lease modifications because it only addressed the flaring issue, but that's just semantics because the remainder of the lease modifications were never appealed. So there's really no question in this case that the lease modifications are valid. And as Mr. Stark related, it ordered the district court to vacate the North Fork exception, and I'll talk a little bit about that more later. Now, on construction. So when we received this decision, we considered what it meant for what we could do in this area. And we concluded that under rights provided under our leases, under the Mineral Leasing Act, and under the Colorado Roadless Rule, we were allowed to continue to build roads within the lease modifications consistent with the Colorado Roadless Rule and the lease terms. We vetted this reasoning with the United States Forest Service and OSM before we constructed. And there was no objection raised to our interpretation. They reserved judgment on certain issues, but they did not object to us beginning work. We also notified the division that we would be commencing work as well. The division was fully apprised of our plans on this. Now, importantly, US Forest Service personnel accompanied Mountain Coal in the field to oversee and check the site conditions for all the road and pad locations and the site conditions. Road work for longwall for panel 2 started in June 2nd and it went through June 4th. Now, the conservations groups contacted us on June 4th, and we agreed to temporarily halt road work given their objections. We did not agree to halt pad work, and I'll explain a little bit more why that's the case. All the parties together moved to vacate the North Fork exception on June 11th, and it was granted on June 15th. So prior to June 15th, we constructed roads lawfully under both our interpretation and because the roadless rule was not yet vacated. The plaintiffs filed their emergency motion in the federal court on June 12th. That's still pending. Pad work, which is not covered by the roadless rule, and this is where an important distinction between what the division is contending and what we believe the law provides. You know, they speak broadly about surface disturbance. The roadless rule only covers specific types of activity, and I'll talk a little bit more about that later. We started work on the pads on June 12th. As Mr. Stark indicated, they inspected. 2 of the 5 pads had been completed at the time they issued their cessation order. So, and again, this is just similar. What you'll see on the left are pads and roads for longwall panel 1 that are not at issue, that are not subject to the cessation order and were constructed a year before. What you see on the right are the 2 pads and the segment of road that were constructed prior to the cessation order existing. Here's a map showing the green is the road that was constructed all prior to the vacator of the North Fork exception, and the 2 circled pads. Those are the ones that are constructed. Now, as Mr. Stark indicated, it halted all surface use outside of longwall 1. No road construction, pad work, drilling, or even travel on the existing road. Again, in our view, this is wildly overbroad. They asserted violations of the Mineland Reclamation Board rules and the permit. And they, as Mr. Stark indicated, wanted an explanation from Mountain Coal as to why our actions are not in direct violation of the 10th Circuit's decision. We have been in compliance with the cessation order. There was a reinspection on July 6th. There's no question about our compliance with all the terms of the cessation order. So let's talk about jurisdiction for a little bit here. So as Mr. Stark indicated, the state's authority to regulate coal mining on federal lands is governed by SMCRA, and SMCRA is an exercise in cooperative federalism. Colorado does have the authority to regulate coal mining on federal lands under the cooperative agreement with the Secretary of the Interior. There are two issues relevant to the cessation order. What activities does SMCRA allow states to regulate? Because it does not allow states to regulate everything. And what activities does Colorado actually regulate? So first of all, there are certain non-delegable authority that SMCRA and Congress made really clear is not provided to the state, that the state has no authority over. These include things like NEPA compliance, the Federal Endangered Species Act, the National Historic Preservation Act, and federal mineral leasing with the consent of the Federal Surface Management Agency. Only the Secretary of the Interior and the United States Forest, in consultation with the United States Forest Service, can interpret and enforce these laws. The cooperative agreement also makes clear enforcement authority here, then this is really important because this is an enforcement action given to the Secretary under other laws, including but not limited to those limited in Appendix A, and that includes the Mineral Leasing Act, is reserved to the Secretary. Only the Secretary can enforce that. And there are multiple provisions in the cooperative agreement, and these are all detailed in the letter sent to Dreams, provides that the state and the Secretary shall not duplicate each other's actions or responsibilities. Now, Mr. Stark pointed out that yes, that there are certain circumstances where the division can resolve conflicts, and there are certain circumstances, particularly related to SMCRA, where the division has an enforcement authority. But this is a leasing dispute. This is a dispute about what are the terms of our leases and what rights they allow, and how those have been affected by the Surface Management Agency's regulations. The division does not have authority over those. This is also highlighted by the fact that all this litigation that's been going on for this decade, the division has not been a party to that. This matter is in federal court with the Forest Service and OSM as parties. Now, Mr. Stark pointed out that they consulted or they talked with OSM and the United States Forest Service, and they did not at that time say you're out of order here. But that's because they want to allow the process to proceed. And both the Office of Surface Mining and the Forest Service are always cautious about undertaking new final agency actions that would supersede or modify actions already committed. So the fact that they didn't at that point jump out and say you're out of bounds here is really of no moment with respect to their authority. Now, as I pointed out, the directive of the cessation order says, explain why your actions are in compliance with this federal court decision. The state is not a party to that federal litigation. The Secretary and the Forest Service are parties. Every question that the state has asked us to explain to them is now being presently litigated in federal court. This is entirely duplicative of what's going on in federal court right now. The issue is exclusively concerned lease rights and restrictions of federal law, matters that are reserved to the Secretary under SMCRA and the Cooperative Agreement. The federal court, the Secretary, and the Forest Service possess ample independent enforcement authority on these issues. For the division to intervene here and insert itself and say, I read the 10th Circuit decision in a certain way, and therefore I'm going to issue a cessation order, that violates SMCRA and it violates the cooperative agreement between the United States and Colorado. It's really important here to understand that these are complex issues and they all turn upon our lease rights. We are not contesting if in fact there was a violation. The argument that that the division has the authority to issue a cessation order, we don't have a problem with that. Of course they can protect the environment, But the issue becomes what matters, the division gets to decide, as opposed to what matters in disputes the United States and the United States court system gets to decide. So that's what authority was given to Dreams and the board. But you can come at it from the other direction too. What authority has the division claimed under its own rules, and the board claimed under its rules? I was very interested to note that in his presentation, Mr. Stark did not cite this regulation. This was the first regulation that we were asserted to be violating by doing work on federal land in the Sunset area. And if you look at this, it's absolutely clear it cannot apply. It says in cases where the applicant proposes to extract coal by surface methods, not applicable here, and where the private mineral estate has been severed from the private surface estate, the applicant needs to submit to the office X, Y, and Z. This is not a private mineral estate. This is not a private surface estate. This was not written, haphazardly. This was not written uncautiously by the division by the board when they promulgated these rules. Because when you have public minerals, you have federal minerals, that's because the division need not enforce these things and need not inquire into legal rights of entry, because there are fully empowered agencies able to do that. So this simply cannot apply. Again, I note that Mr. Stark didn't refer to this in his presentation, and I think that's because it obviously cannot apply. What he did talk to is subsection J, and he quoted this area that talks about the need to provide, this language that needs to provide documentation that we provide a legal right to enter. Now notice, that just means we provide documents saying, here's why we have the legal right of entry. It does not empower the division to adjudicate, to determine the validity of those documents. You will see the quoted passage below that. Nothing in this article shall be construed as vesting in the board or office the jurisdiction to adjudicate property rights disputes. By their own terms, legal right of entry, that's a property rights dispute. Mr. Stark didn't quote that in his presentation to you. It's very clear that the division and the board is not getting into disputes between parties. Now, this rule was satisfied with the BLM, issuance of the BLM lease and the United States Forest Service consent. The board and the division do not pick sides in a property rights dispute. Absolutely nothing prevents the division from consulting with OSM, consulting with the Forest Service. And Mr. Stark presented as, they didn't say we were doing anything wrong, but they also clearly did not endorse the cessation order, or I think we would have heard that. I certainly would have heard that by now, and we've heard nothing to that effect. And the other important thing about this is that this refers to the classic surface mineral type dispute and legal rights of entry. It does not in any way provide third-party rights. Here, there's no argument between the Forest Service, OSM, and Mountain Coal. There's no live dispute. The Forest Service is on our side in the federal litigation. And so there's nothing here. This even goes further to suggest that there's some third-party right by the part of the environmental groups to come in and again, much less the board, which expressly disavows the authority to do that. All right. So there were also allegations of violations of permit terms. And as Mr. Stark indicated, those just track the rules. They fail for the same reasons. And so the upshot of this is that Dreams has failed to articulate a legal basis for a rule permit violation. And as a result, the cessation order exceeds the division's authority and should be withdrawn. Now, so that's the jurisdictional piece. That is not being litigated in federal court presently. And now I want to turn to the merits of the roadless rule arguments. Now, I want to make really clear, everything that I'm now going to say regarding this is a live issue being presently litigated in the federal court of the District of Colorado. That court is going to say something about what we can and cannot do, or whether the plaintiffs have made a claim or cannot. And so in our view, none of this really is something for the board to deal with at all. But the division has asked us to explain what our position is, so I'm going to work through this. So the scope of the roadless rule does not in any way bar all surface activity. That is far too broad. What the roadless rule does is it bars road construction or reconstruction unless there is an exemption. It separately bars tree cutting unless there is an exemption as well. It does not ban use of existing roads or cleared areas, and it does not ban drilling at all. There's no suggestion anywhere in the rule or in the court order that any of that activity is banned. Now, so the result of the 10th Circuit decision, as I said, is that as of June 15th, the North Fork exception was invalidated. And we have valid lease modifications. So what we really have is four issues. First, could we build roads prior to June 15th and the vacatur of the rule? Secondly, could we build roads after June 15th once the rule was vacated? Can we clear methane ventilation boreholes, pads at any time? And can we drill methane ventilation boreholes? So I'll address each of these in turns. Again, here's the issue. It's these two pads on the right and the road between them and connecting up to the other road. And again, just to recap, what's been done is the green road and the two circled pads. Those were done, the road was completed before June 15th. The pads were also completed before June 15th. The future work that's planned is the completion of those two pads on Longwall Panel 2 and the roads that are shown in this map, which is the subject of minor revision 446.
Mr. Drysdale, just a
Yes.
quick question. Can you go back to that map?
Absolutely.
The big black dotted lines, I can't see
Oh,
the.
yes, that
Can you
very,
tell me?
yes, that's very helpful. I'm glad you pointed that out. The big black dotted lines are property line areas. So everything to the west, sort of, you see south, the word South Prong Creek, everything there, that is private land. And so that is not the subject of the cessation order and is just not a subject of this dispute. Everything in the middle section, C1362, that's one of the federal lease modifications. That is the area that's under the subject of the cessation order. There's another federal lease modification to the right that's really not implicated because there's no work presently planned or has been completed in that area. So we're really focusing on that middle section. Is that helpful?
Yes, I guess I was wondering if any of those dots indicate boundaries of the roadless area.
Yeah, so all the area in 1362 that's shown on this map is within the Sunset Roadless area.
Because it is federal and not private.
Well, it's a combination of the fact that it's federal and because it met the characteristics for roadless. If you go further north from these two leases, there's lots of federal land, but it's not within the roadless area because of the condition of the surface.
Okay.
So yeah, so it's not all federal land is roadless. You know, to use the sort of SAT type thing, you know, all roadless area is federal land, not all federal land is roadless area.
My favorite kinds of questions.
Exactly. Okay, so continuing.
Thank you.
So let's first talk about issue one, the roads that were constructed before the rule is vacated. So the road building that we did, we believe is allowed by law, and the United States Forest Service agrees with this on this. That's what they are have argued in federal court. And that could not be clearer. So in our view, that road building, there should be no question about the validity of that road building, and the cessation order should be withdrawn as to those roads. In addition, and this is where the lease rights, the future work comes in, we also believe that it's allowed under our valid lease. And here I'm going to spend a couple of minutes talking about this. So the 10th Circuit vacated the North Fork exception, which is 36 CFR 294.43 C19. Okay, so that was a special exemption for road building in coal mining areas. But there is another exemption, which is totally unaffected by this litigation and continues to be valid, called 294.43 C11I. That provides an exemption where there is a right, an outstanding right, or a right under a statute. It is our view that a valid mineral lease issued under the Mineral Leasing Act constitutes such a statutory right. There is no other, there is no other way to exercise our rights to this coal than to do temporary road building. And therefore, this is precisely the type of scenario that the Forest Service anticipated when they promulgated the rule. Did they anticipate a circumstance where the exemption would be in place, that another exemption would be in place, and then it would be vacated partway through, but the lease was left in place? No, of course not. That's a unique scenario. But the scenario of where you have a valid lease right issued under a federal statute, that was anticipated, and that's what we fall under. There's also a specific exemption in our leases that talks about this. Our leases say that we are required to comply with the rules of the Forest Service when they consent, except to the extent that those are incompatible with the rights that are granted under the lease. An exemption from Title 36, this part of the CFR, when it's incompatible. It's really no question that we cannot exercise our lease rights without being able to build these roads. We cannot physically mine the coal. That's been examined up and down throughout the 10-year history of this dispute. The Forest Service has not addressed this our right in the federal litigation because it has not been necessary. As I indicated, the Forest Service is not in the habit of advancing arguments before they absolutely need to in federal court, because their view is the work that was done to date was lawful, and that this question of what our lease rights are is not something that is directly part of the litigation and before the court, therefore they have not opined on it. But they certainly have not objected to it in any way as we've proceeded. Now, the next question then becomes road building after June 15th, 2020. Now, this is all the same points. Obviously, the rule has been vacated, but we still believe we have rights as I just described. Now, let's talk about pads. There's no dispute that well pads are not roads. They are not governed by the prohibition on road building. Nobody has made any argument that that's the case. What the plaintiffs have argued, and this was not addressed in the 10th Circuit decision because it only came up after the 10th Circuit's decision, was that tree cutting is prohibited. They say you can't prohibit trees. There's a separate part of the rule. You can't cut trees. They say there's a separate part of the rule that prohibits that. This issue was never raised before June 11th, 2020, when they filed their motion. And I go back to this map. These on the left side are all pads that were constructed, in prior years. They're not subject to the roadless rule because they're not roads. So we had to have a right to do them under other authority. Nobody ever argued that we couldn't build pads. And that's because pads are allowed under the rule. So going back to tree cutting, and specifically what it says, there's a separate exception. It says you can't cut trees unless it's needed for an approved management activity. That's 294.42C5. And it's very clear that coal mining under a valid lease with the consent of the Forest Service is an approved management activity. The regulatory history to the rule gives a pipeline as an example of saying that you can clear trees to construct a pipeline. And that's very analogous to what we're doing here. So in our view, there's just no question that we should be allowed to use the pads that have been constructed to date and construct more pads. Now, obviously, we can't construct more pads in other areas if we can't get to them with roads. So in that sense, it's derivative. But the remaining pads that are planned for panel 2, we absolutely should be able to construct those. Now, drilling of MVBs, not addressed in the roadless rule in any way whatsoever. There's just no basis under the roadless rule, under the 10th Circuit's decision, or anything for us to be prohibited from doing that. There's no argument in the federal litigation whatsoever that it's barred. Okay, so then, and this has been much of the heat rather than light that's been associated with this, the plaintiffs like to make a big deal. Oh, didn't you guys already agree that you'd be prohibited from doing that? And they love to quote this sentence from one of our appeal briefs that says that if you vacate the entire rule, it would freeze coal exploration and prevent Mountain Coal from further road building and mining and the lease modifications. Case closed, right? No. And the reason is this sentence was put in place because what the plaintiffs have been arguing throughout this litigation is that once the North Fork exception gets invalidated, it unravels all the decisions that were predicated upon the North Fork exception. Because we couldn't have a lease without the North Fork exception, therefore, if the North Fork exception is vacated, the lease is also vacated. And had the 10th Circuit vacated the lease, we would be stuck, right? But they did not do that. What we were arguing there is pointing out, if you vacate the rule and then you vacate the lease, we're stuck. But that's not what they did. Instead, the lease modifications, as is undisputed, remain valid. And as I've explained, our rights arise under the lease modifications and the recognitions of such rights in the Colorado Roadless Rule. All right, so those are that whole segment there is all stuff that is presently being litigated in federal court as we speak, where a federal decision may come down at any time. Can I say what's going to happen? No, I can't. But I can tell you what's not at issue. What's not at issue is drilling. And as I pointed out, pad work is not covered by the rule. So there's no basis to keep the cessation order in place with respect to pad work. Now, so let me pause there. And this is all a torrent of information. I mean, this is the problem with the division getting involved in a piece of litigation that's been going on for more than a decade with many, many thousands of pages of record and paper and parties and up and down and back and forth, and jumping in and saying, oh, boy, it seems to me like this court order said the following, we're going to stop everything until you explain to our satisfaction why you can do this. So let me pause there, right, and see if there's any questions about our right to build roads, pads, drill, etc. On the surface, either from the board members or from the division. I can't see everybody, so.
Yeah, if it's not super difficult, you could unshare your screen.
Oh,
but
sure, absolutely.
Only just because then we can see more heads.
Yeah, absolutely. Let me do that right now.
There we go.
So I am surveilling the various boxes. Does anybody have any questions?
Maybe Karen, are you good?
I'm fine. I'm fine.
Okay. I do not see any questions.
All right, I've got just a couple more things to go, so I'm going to reshare again here, and then I'll be finished.
Thanks.
Okay, so what are our requests to the board? Go back here. All right, so we request the following. We request that the board terminate the cessation order. We believe that it exceeds the state's authority under SMCRA and the Mine Land Reclamation Board rules. Again, I want to be really clear about this. We understand how this came about. We understand that this was done in the heat of the moment with concerns, et cetera. We have a long, productive relationship with the board. We understand the concerns about legal right of entry, but this is one where we just think the board has gone a step too far in terms of its authority under both SMCRA and the cooperative agreement. We also think that it's incorrect on the merits of the roadless rule. We provided all our arguments in our appeal, that were presented in the brief, and we provided the federal defendant's brief as well too. And they all make clear that at least with respect to the roads that were constructed to date and the pads that were done, that we should be able to use those. And so we believe we have satisfied, both with this presentation and with the materials that I supplied earlier, the cessation order demand. If the division needs any more information from us, we are happy to provide it, either during the course of this hearing or in follow-up to this hearing. So we do request that the cessation order be terminated in its entirety. But I also point out, at a minimum, we request that it be modified because it's overbroad. It covers conduct not covered by the roadless rule, and it covers conduct that was perfectly lawful when done really should be under any argument. And so we would therefore request that if the board does not terminate the cessation order, that it narrow the scope and that it exclude the following things: roads built to date. The roads built between June 2nd and June 4th, which predated the vacatur of the North Fork exception. Second, that the pads which are allowed under the that we can use the pads that were constructed before the vacatur and any pads that we might construct associated with that road after the vacatur. Again, that's not prohibited under the roadless rule. That we be allowed to do methane ventilation borehole drilling wherever we can, wherever we have roads and pads, because again, that's not prohibited under the Colorado roadless rule, and that we be allowed to use longwall road SS2, because again, that's also not prohibited. All these things exceed the scope of the roadless rule. Now, let's talk a little bit about what next steps based upon what the board does here today. If the board grants the appeal and terminates or modifies the order, this is what's going to happen, just so we're all clear. Mountain Coal, we're going to resume work on the pads for longwall SS2, panel 2. We will drill the methane ventilation boreholes for longwall SS2. But we will not conduct further road building on panels 3 and 4 until there is a ruling from the district court. Why is that the case? There's a couple reasons. One is the plaintiff's motion before the federal court has now been pending almost a month. It could come down anytime. While we feel very confident that we're going to prevail in that motion, it's always possible there could be some wrinkle to it, or we may not prevail on every single issue. And what we do not want to be in the circumstances that we are in the middle of building a road and we get some adverse order that then causes problems on the ground, difficulties in reclamation, et cetera, et cetera. So we are going to wait until we hear from the federal district court on that issue. Now, if the board denies the appeal, then we're going to have to really look at taking this to the next level. We're going to have to make a formal request potentially for OSM to intervene in this matter. They have wanted to stand aside. They've neither wanted to take a role in this, again, because of the concern about litigation, the pending litigation, final agency action, all those issues. But we really believe here that the cessation order has exceeded the state's authority. It violates SMCRA and the cooperative agreement, and we would have to look at bringing that to a determination, and then of course judicial relief as appropriate. So we really don't want to pursue either of those options, but we're going to have to look at them if the cessation order is continued, at least with respect to the roads and pads associated with panel 2. So that concludes my presentation. There are, and these are just illustrations of what we would do. Again, just to be clear, we would build the remaining pads that are that are circled, and we've provided all the briefs that were in the federal. We've provided the briefs that's on our view in the federal litigation. We can provide any of the materials or sites provided in this appeal, in this presentation. Our witnesses, Mr. Polos and Ms. Welt, are available to testify if there are any factual questions that you would like to get in further. And so with that, I'll conclude and address any questions you might have. Thank you very much for your time.
Thank you. Are there any questions? Okay, I'm not seeing any questions.
I do have questions on behalf of the division. I just wanted to give the board an opportunity to ask questions first if needed. So if I can go ahead, Madam Chair. Okay. My thanks again for the testimony, and thanks again for the conversations kind of coming into this hearing. I always appreciated the time you've given me in the division. Couple questions that I have related to some of the statements you made in testimony and then in your written material submitted to the board. You've asserted that there's no dispute that the lease modifications are valid. That's on page 501 of the board packet. And then additionally, in your written materials, you've asserted that the court has affirmed the lease. And then again, on page 501 of your written brief, you provide a citation to the court order. I've reviewed the order and I'm not finding language in there that kind of expressly affirms the lease. Can you help me out or help the board out in locating that language?
Sure, and I address this in part in my presentation. And this gets back to, and this is discussed in our brief, where what you had is the federal district court in 2017 or 2018 affirmed the decisions. It said that the U.S. Forest Service consent is valid, and it said the lease is valid. There were only certain issues appealed. The only issue that was appealed to the 10th Circuit was whether or not methane flaring was a feasible and prudent alternative that should have been required as part of the lease and should have been studied more fully in the NEPA. So that's the only issue that was presented to the 10th Circuit on appeal. The 10th Circuit rejected that. The net effect of that is to affirm the leases. There's no basis to argue that the leases are, and even the plaintiffs are not arguing any longer. They did initially, but they're not arguing any longer that the leases aren't valid. So when the only challenge that's raised on a lease gets denied, by definition, that lease is affirmed and valid.
Okay, and my follow-up question, and this may be an unfair question for you because I'm going to ask you to potentially speak on behalf of BLM. If that's the case, then why hasn't or won't the BLM issue such a statement to the division simply stating the leases are still valid?
Well, this gets back to the issue that I talked about before, which is, first of all, it's clear, I believe it's clear from the decision, and this is a matter in present litigation in federal court, right? So the federal government is very reluctant to issue statements, decisions, et cetera, to anybody because of the concern that it raises a new final agency action that could be separately challenged in court, all that kind of stuff. So, but I can tell you that if the Forest Service or if OSM believed that what we were doing was unlawful, they certainly would have told us, right? Because they don't want to get in the mix to this. So again, the fact that the federal government hasn't issued a decision or a written statement or something like that is not something unusual. The federal government does not make proclamations that it does not absolutely have to. Now, again, we'll have to force their hand potentially if the board affirms the CEO, but I don't think we need to get there in terms of a resolution.
All right, thanks. I've got no further questions.
Any other questions or discussion for Mr. Drysdale? Mr. Timmons, are you okay if we take a bit of a break here for a second and stretch our legs and come back and then hear your presentation?
Sure, that's fine.
Okay, it's 10:23. You want to go all the way to 10:30? Is that fine? Okay, we'll see everyone back here at 10:30. Thank you.
Problem.
Making sure we get Alyssa back at least so she can, oh, oh, there you are. You just showed up. Jim, is Jeff in the same room as you, or am I waiting for him as well?
There he is.
Yeah,
Okay.
he's back. Oh,
Okay.
he's-
And okay, everyone comfortable with us getting this going back again here? All right, we'll have a presentation from the interveners. Mr. Timmons.
Great. Thank you, Madam Chair, members of the board. My name is Daniel Timmons. And again, I'm here on behalf of Wild Earth Guardians, High Country Conservation Advocates, Center for Biological Diversity, Sierra Club, and Wilderness Workshop, referred to collectively here as the conservation groups. I also have my co-counsel, Ted Zukoski, on the line as well. So really, we're here to support DRMS and asking this board to uphold the cessation order. And before I sort of get into my prepared presentation, I just kind of want to offer a sort of initial high-level response to Mr. Drysdale. He ended there sort of talking about waiting for the district court to issue an order on our remedy motion, and said we don't want to be put in a position where in the middle of building a road and we get, you know, essentially an adverse ruling from the court. But Mountain Coal had no problem going out and bulldozing nearly a mile of a road when it knew that that vacatur order was coming from the district court. And again, I will go back to that sentence that Mr. Drysdale knows that we love to quote, because they plainly represented to the 10th Circuit their position that vacatur of the North Fork exception would freeze coal mining. They didn't get the result that they wanted, and so they went out and bulldozed anyway in advance of that district court formal order. But with that, I will get into my formal presentation. Just to confirm that everyone can see this.
Yes, thank you.
Great. So I want to take a moment to just sort of step back and remember what this controversy is really all about. This is the Sunset Roadless area. It's protected forest on the banks or the flanks of Mount Gunnison, and it's immediately adjacent to the West Elk Wilderness area. There's alpine forest, there are alpine meadows, beaver ponds, abundant wildlife, deer, elk, bear up in this area. Members of the conservation groups and other members of the public use this area for hiking on that Sunset Trail that cuts through the Sunset Roadless area and into the West Elk Wilderness area, bird watching, hunting, other outdoor recreational activities. This is a very special place, and the public is very concerned about road building and coal mining on this area, as evidenced by the letter from the Gunnison County Commissioners that has been sent to the board, was also included in our materials, as well as protests, unprecedented protests at both the Forest Service office and at on the Forest Service lands themselves. Again, this is a very special protected place, which the public and the conservation groups have spent years trying to protect from the advances of the West Elk Mine. So the Colorado Roadless Rule, as we've talked about, prohibits construction, road construction, except for narrow exceptions. One of those exceptions being when a temporary road is needed for coal exploration in that North Fork coal mining area. So that's the North Fork exception. But as we have heard from both Mr. Stark and Mr. Drysdale, that exception is no longer valid. It has been essentially stricken from the books by the 10th Circuit and that formal order from the district court vacating this exception to the roadless rule. And again, I'll get more into some of responses to Mr. Drysdale's statements regarding the statutory right and that sort of idea of other exceptions being applicable to this. But it's clear on its face that this was the exception that was used by the Forest Service to justify Mountain Coal's lease modification, and it was not considering any other exceptions, in particular a statutory exception, which is completely inappropriate in this context. So the timeline, I think, has been generally gone over here, but I will just note, back in March was when we had the original 10th Circuit opinion. The formal mandate sending jurisdiction back to the district court was issued in April. And during that sort of limbo period after the 10th Circuit opinion and before that federal district court order formally vacating the North Fork exception was when Mountain Coal went out and built those new roads, which is of course confirmed by the aerial inspection. I will also note that Mr. Drysdale indicated here today that the pad construction was all completed by June 15th when the federal district court's vacatur order issued. That is inaccurate based on the testimony that was provided by, I believe it's Weston Norris, representative of Mountain Coal Company, in the record at page 525, that pad construction continued through June 16th, the day after that vacatur order, and essentially only stopped when DRMS indicated that the formal cessation order was on the way. So the federal district court order did not stop Mountain Coal's construction activities. So I will also note that it was on June 18th, I believe, that the on-the-ground inspection where representatives of conservation groups accompanied DRMS staff and saw this newly blasted road, bulldozed road, through previously pristine and unroaded aspen forest. There were substantial amounts of aspen trees that clearly had to be felled for this road and were piled up by the side of the road. You see the slash of the road through the forest that's clearly going to be visible for miles around. And this is one of the well pads, a large area, graded, flattened, denuded of vegetation. You know, essentially a moonscape in this previously unroaded, undeveloped, nearly untrammeled landscape. This is why we're here, and this is why the public cares. The Sunset Roadless area is a protected roadless area and should be maintained that way unless there's a valid exception to that that authorizes road building, tree felling, and other service disturbing activities. So Mr. Drysdale has made, Mountain Coal has made an argument that the state essentially lacks authority to issue the cessation order and relies on principles of cooperative federalism to make that argument. But Mr. Drysdale ignores the cooperative part of cooperative federalism and conflates the federal non-delegable duties under the Mineral Leasing Act and the National Environmental Policy Act, the Endangered Species Act, with the state's clear role under SMCRA, and in particular in the SMCRA permitting and enforcement process. Now, there's no question that the state cannot issue a coal lease on national forest lands, but the state clearly has the authority under that cooperative agreement to assess compliance with its own statutes, as shown here on this slide, as well as its regulations, and in section C, the applicable terms and conditions of the federal coal lease. This is from paragraph 7 from the cooperative agreement. Now, we do not believe that the board needs to interpret the terms of the federal coal lease to resolve this case, but the idea that the state lacks that authority is simply wrong, given the plain language of the cooperative agreement. You know, upholding the cessation order does not mean that the board has to dive into the terms of the lease modifications or assess their validity or the Forest Service's consent. The case is really about the 10th Circuit's vacature of the North Fork exception and what that decision means for Mountain Coal's right to build roads and to cut trees within the Sunset Roadless area. So again, so it's clear, as Mr. Stark indicated, the state has primacy under SMCRA, the primary responsibility for review of permit applications under cooperative agreement paragraph 8, as well as the primary enforcement authority under SMCRA and governing compliance with the terms of the cooperative agreement, the program, and the permit conditions, cooperative agreement paragraph 17. And so one of those terms that is one of those permit terms, permit requirements that the state has the right and really the obligation to enforce is the legal right of entry requirement. And so here, it's clear that the applicant is required to demonstrate a legal right to enter and to commence surface coal mining operations. Now, Mr. Drysdale says that basically this is a check the box requirement, that as long as Mountain Coal says that it has a legal right to enter, then the state has no right to question that, because any sort of questioning of Mountain Coal's assertion of a legal right to enter would be a property rights adjudication. That is simply not the case. The state clearly has the ability to evaluate the legal right to enter and to assess whether or not, in particular here, Mountain Coal has the right to continue building roads and to continue cutting trees despite the vacature of the North Fork exception. Mountain Coal, in its written materials, its response to the state, says that the state lacks the authority to, quote, second guess the positions of the federal agencies or make its own independent judgments on the legality of those instruments or permittees' compliance with them. It's simply wrong. The state has that independent authority under SMCRA. But even if it's right, even if Mountain Coal is right and the state cannot second guess the federal agencies, there's nothing to second guess here. There's nothing to defer to. The lease modifications and the Forest Service consent predated the vacature of the North Fork exception. So they provide no guidance whatsoever regarding Mountain Coal's post-vacature rights. Again, the federal government has not weighed in this proceeding, and really has not weighed in at the district court level regarding the authority of Mountain Coal to continue building roads after vacature of the North Fork exception. Again, at the district court level in that briefing, the Forest Service focused entirely on that limbo period between the 10th Circuit decision and the formal order from the district court formally vacating the North Fork exception. And they say that, yes, the activities basically essentially saying that because the activities took place before the district court acted, that the Forest Service there was nothing they could do, and that the activities were lawful because the district court had not yet acted to formally vacate the North Fork exception. Again, we disagree with that premise. I mean, I think that it's clear that at the time the 10th Circuit acted, everyone knew that the North Fork exception was going to be vacated, and there was an obligation to treat that legal opinion as binding. And so the idea that Mountain Coal and the Forest Service are presenting here, that when you get a bad decision from an appellate court, that as long as you rush out and do whatever the court has told you not to do before that the mandate issues or the remand gets formally put in place, that you can get away with it is simply outrageous. And again, the 10th Circuit fully understood what vacature of the North Fork exception meant. And yes, this is the sentence that Mr. Drysdale has noted we continue to refer to, because it's very clear that Mountain Coal, under duty of candor to the 10th Circuit, represented that vacature of the entire North Fork exception would freeze coal exploration in the exception area and prevent Mountain Coal from further road building and mining in the lease modifications. This would certainly result in bypass of the coal in the lease modifications. So Mr. Drysdale indicates that he was assuming when he wrote this in his brief that the lease modifications would also be vacated. But the brief had separate sections on the remedy, one describing the remedy for the claim regarding the North Fork exception, and a separate section regarding remedy for a lease modification decision. The court understood Mountain Coal's position that if the North Fork exception was vacated, it would mean they could not continue building roads in the lease modifications. Again, the language here in the lease modifications simply would not make sense if he was assuming that the lease modifications were gone, because there would be no lease modifications for coal to be bypassed in if the lease modifications themselves were also vacated. Again, the 10th Circuit understood what it was doing and has conclusively resolved the question of whether or not road building can continue in the Sunset Roadless area. Mountain Coal is really asking this board to turn a blind eye to the 10th Circuit's decision and the vacature of the North Fork exception, and basically putting out a position that that decision was meaningless on the ground, that the 10th Circuit was saying, yes, this roadless rule is back in place, but it doesn't matter because Mountain Coal got a lease under an exception that was never validly promulgated, and yet can now bootstrap that improper rule promulgation into a statutory right that allows them to continue building roads despite the vacatur of the North Fork exception, the entire legal basis for allowing road building and cutting trees at the West Elk Mine, it's frankly sort of baffling to me how this argument actually holds together. Finally, I want to note that as Mr. Fugate was asking, the 10th Circuit did not affirm the lease modifications. They said that the arguments brought by conservation groups were not enough to invalid the issuance of the lease modifications. That BLM and the Forest Service were not required to consider a methane flaring alternative before issuing those modifications. But again, that challenge was entirely focused on the issuance of the lease modifications at the time. And the 10th Circuit's directive to vacate the North Fork exception left no wiggle room. It was in its entirety. And there's nothing in that opinion to indicate that Mountain Coal somehow maintained a right to build roads after vacatur of the North Fork exception. Again, Mr. Drysdale is right that we're not challenging the validity in its entirety of the lease modifications. Those lease modifications may still technically be valid, but again, that doesn't mean that they authorize new road building or tree cutting. And the cessation order tracks this distinction perfectly, because Mountain Coal can continue mining coal, its underground mining operations, based on the roads that were constructed prior to that 10th Circuit decision. So that's essentially Sunset Panel 1. Those roads were built last summer. There's no, yes, the litigation was ongoing at that point, but there wasn't a court decision indicating that the North Fork exception was invalidly promulgated and hence never lawfully in place. But at this point, unless a new cessation order is promulgated, unless a new exception to the roadless rule is promulgated, the cessation order should remain in place, because absent an exception to the roadless rule, Mountain Coal lacks a legal right of entry to build any new roads. Now, again, Mr. Drysdale also raises arguments that Mountain Coal now has a statutory right to build those roads. And it's true that there is an exception in the roadless rule for statutory rights, but that's not what Mountain Coal has. If Mountain Coal had a statutory right to build or to mine coal and build roads, then there never would have been a need for the North Fork exception to be in place anyway. And again, the company cannot bootstrap an invalidly promulgated exception to the roadless rule to get its lease and then bootstrap that lease into some sort of statutory exception that allows it to continue building roads. The legal underpinning of that lease is gone. And while the lease itself may still remain in place, it does not authorize road building. Mr. Drysdale focuses on the fact that as a practical matter, additional mining in panels 2, 3, and 4 is likely precluded if the company cannot continue building roads. But the company knew when it acquired those leases that it was in the roadless area, that there were legal challenges to the validity of the roadless rule, and that it was essentially taking the risk of additional or of that roadless rule exception being vacated. I think I would agree that the Forest Service could not, without violating the terms of the lease, promulgate new restrictions on road building that were in conflict with the terms of the lease after the lease was promulgated. That's not what happened here. Here, the roadless rule was in place, and that exception was the only legal underpinning to allow roads, but that exception was never lawfully in place. And so once that exception was vacated, essentially you go back to ground zero, and yes, you can continue using the roads that were built before the 10th Circuit made that decision. I think that there is, I won't even actually get into that. But the idea that, again, that they can bootstrap this invalidly promulgated rule into a statutory right to continue mining forever and to continue building new roads is simply inaccurate and does not, it doesn't comply with what the 10th Circuit did. On the question of pads, and in particular, the pads, well, I guess there's a question of the pads that have already been cleared, and then the pads along the road the road has been built, but the pads have not been cleared. Starting with that second part, where they have not cleared the pad, clearing a pad requires cutting trees. They do not have the right to continue cutting trees under that lease because the North Fork exception is the basis for that authority. Similarly, separately, with respect to drilling wells on the pads that have already been constructed. Again, those new well pads were built after the 10th Circuit decision and mandate. And actually, at least one of them, construction continued after the district court's vacatur order issued on June 15th. But Mountain Coal was clearly trying to take advantage of the delay in the district court order and the Forest Service's apparent belief that the 10th Circuit decision didn't mean anything until the district court acted. And again, that's simply wrong. And that construction activity, that well pad clearing, was unlawful. And even if it wasn't unlawful at the time, now that vacatur order has formally issued, those pads have no business being in the roadless area. There was never a valid exception in place to authorize that road building and that tree clearing activity. And so Mountain Coal should not be allowed to benefit from its unlawful construction activity and its attempt to thwart the 10th Circuit's mandate. Mountain Coal comes with what we call unclean hands and cannot be permitted to benefit from its attempt to get around the 10th Circuit decision ordering the vacatur of the North Fork exception. So no additional surface disturbing activities, period, should be allowed in the Sunset Roadless area unless there's a valid exception in place that authorizes that activity. So just to briefly conclude, under SMCRA, it's clear that the state has the authority to enforce its legal right of entry requirement. But with the vacatur of the North Fork exception, Mountain Coal lacks that legal right of entry to build roads or to cut trees within the Sunset Roadless area. So we ask that the board maintain the cessation order until the Forest Service promulgates a valid exception to the roadless rule which covers the Sunset Roadless area. Thank you. And I'm happy to answer any questions.
Are there any questions from the board? Mr. Timmons, I have a question. At the beginning of your presentation, you said that you included a letter from the county commissioners. Can you tell me what page that's on in our packet? Please.
It's Exhibit M, and it's pages 740 and 741.
Okay.
And that was sent on July 13th.
in the agenda item packet. Okay, so I'm sorry, can you repeat that? 7 what?
740 is where it
740.
starts.
No, I don't have it.
Sorry, still scrolling. My 740, okay, 745. Okay. All right, I'll take some time to read that if anyone else wants some other questions. Thank you. Any questions from the division?
No questions from the division. Thank you.
Further discussion before we go into rebuttal from the division?
I do have some rebuttal, and I believe Jim may have some comments as well.
Sure.
If we have time. Okay. So in an effort and out of respect for the board's time, I'm not going to kind of rehash the statutory regulatory authority that we believe the division had when it issued the CO, and that the board has in our request that you affirm the CO. I am going to touch base on those because that is kind of the foundation, at least we believe that's the foundation of this hearing. That's the most important aspect of this hearing is the authority. You heard some testimony from Mr. Drysdale on behalf of the company as to why we lack the authority, why what the division is doing here ventures into areas of authority exclusive to the federal government and or into matters being resolved eventually by the courts. We disagree. And that's what I want to do is clarify that the division is not making any determinations or adjudications regarding the validity of the leases. We do recognize, and the company pointed out the statutory authority that the division and the board do lack authority to adjudicate private property disputes. That's not what we're doing here. As you heard from Jim in his original presentation, the focus and thrust of the authority of the CO is really related to right of entry and lack or failure to maintain right of entry in light of the court's vacatur of the North Fork exception. And that exception, in our view, is kind of the foundation for access to conduct these activities. And that's, I think it's important, again, to point out the language in the CO itself, and this is page 499 of the board packet. You know, the abatement is seeking information from the company regarding its assertion that it maintains legal right of entry to the Sunset Roadless area, and importantly, why it is not in direct conflict with the district court order vacating the North Fork exception to the roadless rule. So that's really the information we were after from the company is, in light of a fairly clear order from the court that the exception no longer exists, how or why do you still have right of entry? And I'm still not sure that the information that the division has received in written form or in arguments today that we quite have that. So before I get there, I just wanted to kind of clarify that at no time was the division adjudicating the leases. We're taking no position on the validity of those leases. We recognize or realize that is not the role of the division here, but we absolutely do have the authority regarding right of entry and seeking information from a company regarding the loss of right of entry based on a court order. So again, to run through the statutory citations, and I'm just going to put back up the presentation from Jim. So give me a second here as I try to share my screen. Let me know if you can see that.
We can see it.
So again, starting with the division's authority to issue the CO, we've outlined that in section 123(1)A, as well as the kind of the mirrored regulatory language. So clearly there's authority by the division and the board to issue the CO or affirm the CO based on the concern that it is causing and can reasonably be expected to cause significant environmental harm to land, air, or water. Again, the CO is based on section 110(2)J, which is the right of entry. That's, as this board is aware, in all permitting activities that you receive, both coal and minerals, right of entry is an important aspect of a permit. You have to have a right of entry to commence. You have to maintain it throughout the life of mine. And we believe that with the order of the court, it brings into question whether or not they still have valid right of entry. Now, again, the division has made the determination that that court order vacating the North Fork exception, we've determined that they have lost right of entry and have afforded the company the ability through an abatement process to explain why they believe they still have it. Again, this is the regulatory citation on right of entry. And then finally, turning attention back to the cooperative agreement, some of the assertions testimony from the company is that we've exceeded our authority under the cooperative agreement, which simply is not the case. Again, to reiterate some of the provisions that Jim had touched on, the provisions in Article 7, paragraphs 17 and 18 are very clear that the division has primary enforcement authority, and that includes the ability to issue a cessation order. Now they're saying that under Appendix A and getting into the Mineral Leasing Act, that again, we've ventured into federal authority territory, which again, I disagree with. We're not interpreting the leases. We're not issuing a lease. Our cessation order is issued based on failure to maintain right of entry, which is squarely within the division and the board's authority. We are not venturing into federal territory here. And so I guess before I move on, I just want to make sure that if the board does have any questions on the authority, the various statutory legal citations, that we're available to answer those questions before I move on. And then I believe Jim Stark will have some rebuttal as well. So I'll pause for any questions you may have on our position on legal authority. None? Okay. Then again, I'm going to close with kind of reasserting that this CO does not adjudicate private property rights. We believe that's what the court did. It's on clear legal foundation. There's nothing in any of the citations or cooperative agreement arguments presented by the company that undercuts or undermines the division's authority here. So I'm going to let Jim fill in some details if he has any on some of the other circumstances around the issuance of the CO, but from a legal foundation, legal authority perspective, this CO is supported by the law.
All right, thank you.
I only have a couple.
I only have two things. The first, I want to dovetail off what Jeff said. It's clear that the division does not have the authority to adjudicate property rights. I mean, it's in the statute in multiple places. It's in rules in multiple places. Again, that's not what we're doing. We were presented with information in the form of a court decision that says that the company no longer maintains legal right of entry for the Sunset Roadless area. That's what this CO is based on. It's clear that all of the work done before the official vacation of the North Fork exemption up until June 15th, that was done legally. That's why we didn't issue a notice of violation on this. If we had thought that was done illegally, we would have issued a notice of violation probably in addition to a cessation order. So we're not disputing that fact. I think Mr. Drysdale brought that up as well. So we agree with that. But again, if we are presented with clear information that a company no longer maintains the right of entry, doing nothing is abdicating our responsibility under the act and the rules. So again, issuing the CO is is where we ended up. The fact that these federal agencies are mute, that doesn't come into play in our decision-making. It'd be nice if they would chime in and maybe give a little more clarity. It'd be nice if the courts chimed in and gave more clarity, but that doesn't change the division's role and the division's authority in this matter. So, if there are any questions, I can answer any questions on, any of these processes or the CO in more general terms, more specific terms.
I'm not seeing any questions, Jim.
Okay, thank you.
Thank you. We'll go with remarks and rebuttal from the operator, Mr. Drysdale.
Yes, thank you. I can be fairly brief here. A few things. Let's dovetail off the rebuttal from the division and from Mr. Stark and Mr. Fugate. So going from the back end. So it appears now clear that the division is saying that the road work that they agree and this is the position articulated by the Forest Service, that the road work that was done before the formal vacatur was lawful. Okay, the division is in agreement with that. The United States Forest Service is in agreement with that. And yet the cessation order prohibits us from using those roads. That seems to me to be pretty clear admission that the cessation order, at least with respect to use of those roads, is overbroad. I've seen nothing to suggest. So again, what we have here is a mixing of concepts and an overbreadth of statements. When the division says we're not questioning, we're not interpreting federal law, we're not interpreting what the Forest Service does, we're just interpreting this federal court order in a matter for which they were not a party to, and then they are translating that into a right of entry question. That court order said nothing about legal right of entry. Right of entry was not an issue in the case. The issue in the case was the validity of a rule. What implication that might have for the rights of the lessee is an entirely separate question. And so the idea that there's this clear order saying that you don't have a legal right of entry is just simply false. So and again, the issue would be if the Forest Service was taking a different position, well, then we'd be in a different scenario here. If somebody had said, no, we disagree, you can't do this on the federal side as a matter of interpretation of federal law, we'd be in a different position here, but we're not. This is the division inserting itself in interpretation of a case that it has not been a party to in any respect. Now, so when Mr. Fugate says we made a determination of what this court order means, what they are saying is we are interpreting this law. We are concluding it to, we are interpreting it to mean a right of entry decision in contravention of positions taken by the federal government in the litigation and elsewhere. Now, Mr. Fugate indicated that he's not confident we have yet provided the information that shows how we have a legal right of entry. We've provided the briefs, and I'd like to take a step back here. Part of the cessation order says, show us why you have a legal right of entry notwithstanding your lease. That's like saying, show me how you have a right to drive without showing me your driver's license. It is our belief that the lease is what confers, the lease and the rule is what confers that right. And we've articulated that in the briefs that we've provided, and as I've explained today. We're happy to provide more information if that's useful, but we think we've provided everything the division could ever need to make that, to evaluate that question. We have satisfied the cessation order in terms of providing that information. So that's an important piece. I note that neither the division, neither Mr. Fugate nor Mr. Stark cites the same provisions of the cooperative agreement or SMCRA that the conservation groups has. And I think that's because it's pretty clear that when it says all these three units shall implement their responsibilities, they're not saying you implement them all for each other at the same time and duplicatively. Each still has its own role as it's clearly laid out in the statute and in the cooperative agreement. So that doesn't get anybody anywhere. Again, I disagree when they say that we are that we are not adjudicating a property right, that is exactly what you're saying. When you're saying, we don't believe you have a legal right of entry, you are interpreting a federal court decision, again, in a matter in which you are not a party. Now, I would note with respect to the conservation groups, their arguments are at war with themselves. They keep saying, they keep expressing bafflement that we have any rights under these leases while conceding that the leases are valid. Their arguments all go to why they really thought and had argued in at least in the district court that if the North Fork exception is vacated, that withdraws the legal underpinning of the lease, and therefore the leases should also be vacated. But that's not what the 10th Circuit did. And so it's they who are at war with the 10th Circuit's decision, not us. And this business of, well, yes, you have a valid lease, and you just got to figure out how to deal with the fact that you can't build roads is, again, is a negation of the remaining parts of the lease. There's no dispute whatsoever that we cannot mine this coal unless we can build roads and pads. And so they're just arguing you should really invalidate the lease by other means. So there's that really is, they're at war with the 10th Circuit, not us. Now, I did want to respond briefly to Mr. Timmons' contention, and I don't believe I said that the pad construction was complete before the vacator was ordered. If I said that, that was a mistake. The pad construction was complete before the cessation, the ones that we're talking about here, was complete before the cessation order was issued. We didn't do any pad construction after the cessation order. And again, there's no, I'm not hearing any argument whatsoever. So you can, the division and the conservation groups can talk broadly about right of entry, but that's not what the roadless rule is. The roadless rule prohibits very specific and limits and exempts very specific sorts of activity. So I've heard nothing that says why we can't build why we can't build pads where we have, as the division now admits, we have lawfully constructed roads. And I haven't heard anything that suggests that we can't drill wells where we have pads, constructed. There's absolutely no response to that. The conservation groups say, well, it's all sort of fruit of the poison tree, but that's the same argument as to why the leases themselves should be invalid, and that's not what the 10th Circuit ordered. The ultimate issue here is that the 10th Circuit clearly could have invalidated the lease modifications if it so chose to because of the error in the North Fork exception. There's really no dispute about that, but it did not. It was an equitable determination. And now that we have these leases and they have not been overturned, what rights do they provide? And we've articulated what rights they provide. We've not heard any significant rebuttal to that, either from the division or from the conservation groups. And so, so at a minimum, our use of the lawfully constructed road for pad 2 should be allowed, for panel 2 should be allowed. The pads should be allowed, and drilling should be allowed. I've seen no argument from the division why we shouldn't be allowed to do that and why the cessation order shouldn't be modified accordingly. So with that, I'll conclude. And as I said, I'm happy to answer questions, and I'm happy to provide any more information that the division might require regarding right of entry. But we think we've provided what they've asked for.
Questions or comments from the board or division? Or, okay. Seeing none, the interveners, a rebuttal, please.
Thank you, Madam Chair. Very briefly, Milton Cole's argument essentially boils down to an argument that the 10th Circuit decision means nothing. But the 10th Circuit did not need to vacate the lease modifications in order to halt road building and tree cutting. Because of Milton Cole's clear representation to that court that that's what vacature meant. That vacature meant road building would stop and coal mining on panels 2, 3, and 4 would not be able to go forward. Again, that doesn't mean the lease modifications are necessarily invalid. If the Forest Service puts in place a new exception, tries for a third time to get it right, and they do, then that lease modification would still be in place. And if the company is concerned that it cannot continue to mine coal and meet its obligations under the lease, then it could request a suspension of the lease as it works with the Forest Service to try to put together an exception back in place, again, for the third time. At the end of the day, the 10th Circuit decision, when it vacated the North Fork exception, the court knew what it was doing, and it knew that it was stopping additional road building and additional tree cutting on the Sunset Roadless area. In its equitable discretion, it did not necessarily go and vacate the lease modifications in their entirety, which is allowing Mountain Coal to continue to mine coal in the interim. And so the coal mine has not been shut down, and it can continue mining in the interim until the Forest Service puts in place a valid exception to the Colorado roadless rule, which is now the law of the land. So if there are no further questions. Thank you.
Thank you. Any questions for Mr. Timmons?
I have one brief thing, if I could, Your Honor.
Sure.
Ms. Wareham. So I just want to respond to 2 points. One, the contention that the 10th Circuit's decision meant nothing. Let's be very clear about this. The North Fork exception covered 20,000 acres. The deficiency that the 10th Circuit identified related to the failure to study adequately an alternative that would have excluded a few hundred or thousand of those acres. We had argued to the 10th Circuit, you should limit, if you vacate the rule, you should limit it to that area where the defect was. The 10th Circuit did not accept that request. But it doesn't mean it means nothing. It means that there's no road building allowed, and the Forest Service can't approve such a thing inconsistent with the roadless rule for some 19,000 acres of this valley. The vast majority of this is not at issue. That 10th Circuit decision means quite a bit, and the roadless rule means quite a bit. But what the 10th Circuit did not do, as plaintiffs admit, is go as far as they wanted and validate these leases. And so the real question here is, with valid leases, what can we and cannot do? The conservation group's argument, and somewhat to a certain extent, at least the division's argument, is that you've got leases, good luck mining them. If you're unhappy with the fact that you have to pay, that you've paid bonus bids for the entirety of this coal, and you have to pay, you have diligence requirements, well, then you can ask for suspension. So you have leases, but those leases are useless with respect to anything where road construction had not already occurred. That is not what the 10th Circuit indicated, and there was no hint that the 10th Circuit was intended that result. So with that, I'll conclude.
Any other questions? Shall we move forward with a closing statement from the division?
On this, sorry, Les. I would request the division go last, since we're in defense of the cessation order.
Sure, that's fair. Would you is there a preference of the operator going next, or would we prefer that Mr. Timmons? How about Mr. Timmons going?
Okay, thank you,
Thank you.
Madam Chair. It's clear that this that the 10th Circuit's decision vacated the North Fork exception. The North Fork exception is the only legal underpinning for road building and for tree cutting in the Sunset Roadless area. That vacature was not simply prospective, but retrospective. There has never been a valid North Fork exception. And so the company's attempt, again, to bootstrap an exception that was never validly promulgated into a lease, and then somehow frame that lease as providing them with a statutory right to continue building roads, simply does not hold water. The state clearly has authority to enforce a legal right of entry requirement under the cooperative agreement and its own statutes. That is what the board is being asked to do, to uphold that cessation order, which enforces a legal right of entry requirement that the company no longer has. Thank you.
Thank you. Mr. Drysdale?
I don't think I need to respond any further to those points. Again, we've made our arguments clear. The thing what I would really ask here with respect to the division is, what the division is asked for here is just a blanket affirmance of the cessation order. And yet I think as we've explored here, there's significant ways in which that cessation order was overbroad and in error, frankly. The division cited a provision of the rules that they have not even attempted to defend here, the suggestion that we were violating them as I went through. There's been no effort by anybody to defend that alleged violation. And they've prohibited conduct that I think they've admitted here we should be allowed to do. If the road to panel 2 is lawfully constructed, we should be able to allowed to use the road on panel 2. If they haven't made any argument as to why pad work is precluded, and that's just not covered by the roadless rule. And again, plaintiffs have done nothing to say other than the fact that it's all tied to the 10th Circuit to suggest that's bad. So if the road is lawfully constructed and the pads are lawfully constructed, then we should be able to both use the pads and drill the wells that are on the pads that were built to date, and construct the remaining pads that would offshoot of Road 2. I really do not see why the cessation order has to continue to extend to that stuff, given what the division has acknowledged today. So again, we have significant issues regarding jurisdiction. We have significant issues regarding this. I would note that the plaintiffs keep saying the cessation order should extend until there is a new North Fork exception put in place. They're asking the division and the board to ignore whatever ruling comes out of the federal district court. If the federal district court says that what we've done was lawful and would be lawful, I can't imagine how the cessation order could be continued in that context, since the whole basis of this was interpretation of federal court orders. So that's wildly overbroad as well, too. So again, there are significant issues. These are complicated questions that have been litigated for years in federal court, on federal lands, regarding federal agencies. We don't think the division has a role here, but to the extent that they maintain they do, it's at least got to be modified in scope, to address the things that even they concede were lawfully done. And I'll conclude with that.
Thank you. Closing statement from the division.
Thank you. So the division believes it's clear that it has the authority under the Act, under the rules, and under the cooperative agreement to both assess the legal right of entry and to issue a cessation order. And it's done both. The division, as we've heard, is not adjudicating property rights, but relying on a district court decision that vacated the North Fork exception to the Colorado roadless rule for the Sunset roadless area. There's no dispute from anybody here that the North Fork exception has been vacated. Okay, everyone is in agreement on that, so that's not even a question. The division believes that it's also clear that the vacature of the North Fork exception removes MCC's Mountain Coal's legal right to enter. Without the ability to build roads in the North Fork exception area, they're not allowed to build roads in the North Fork exception area. I mean, I think that's pretty clear. Again, the fact that federal agencies are mute, it's not a valid reason to continue road building or to vacate or terminate the cessation order. The division's job is really, when it boils down to it, is to protect the environment. It's within our legal authority to do what we did, and doing nothing is really an abdication of our responsibility as a regulatory agency. Vacating the CO will lead to more road building in the Sunset Roadless area and more disturbance in the Sunset Roadless area. What the division is asking is that the board uphold the CO, uphold CO 2020-001 for the West Elk Mine. Thank you.
Thank you. Is there questions for anyone before we go into discussion in the matter?
Just
Go ahead, John.
Jeff or whatever, tell me again about, the Mountain Coal is asserting that you are, you're taking advantage of property rights when you close the roads, but you mentioned, I think, Jeff, that it's not only the job of the permittee to have access, but to maintain access. Kind of explain that a little bit, maybe, for me.
Sure. Again, the statutory citation for legal right of entry, I'll pull that off just to start the conversation. It's 3433.110.2J, and then the corresponding regulation is 2.03.6. It's clear that a requirement to commence mining operations, gain your permit is proof of legal right of entry. It's your access question, essentially. And then there's an ongoing right to maintain that right of entry. Obviously, we don't want operators to commence a mining operation, move forward with impacts, create affected land, and then somehow lose access and therefore lose their ability to complete reclamation. So that's the kind of ongoing obligation to not only have right of entry to commence operations, but then maintaining that right of entry to continue operations and ultimately complete reclamation.
And what you're saying is that the 10th Circuit took that away.
That's the determination the division made
Access.
based on that clear order from the court that the North Fork exception has been vacated. That goes directly to, again, the question posed to the operator is, what impact does that have on your right of entry? The division believes that the vacature of the exception, essentially they've lost their right of entry under that vacature.
Okay, thanks.
Other questions currently? I have a question. It might be for Mr. Polis. I wish that Forrest Luke was here because he is our coal miner here on the board, and I understand hard rock mining and block caving more. Can you explain to me, when you're in your mine plan, are you already underground underneath that portion where you need to build the venting, or do you do the venting and then go underground under it?
We are already mined in that area now without the mine ventilation bore holes. Then it's doubtful we'd be able to long wall that panel or extract that reserve.
Because primarily that's a safety issue?
It's part of our ventilation plan, yes. And if the gas gets to the level that it needs to be vented, then we have no way to mine.
Okay.
In order to keep our miners safe. The whole idea of the mine ventilation boreholes is for safety of the miners. It gives us another weapon to allow the gas to not accumulate in the places where men and equipment work.
So you're already you're under that area already underground, and then you just need to, you have the math kind of set apart to say, we know how much, I think you mentioned maybe 100 yards or something you do this. I'm sure you assess.
It depends on the lay of the land and how much of an area we figure we can influence with each mine ventilation borehole. We have had failures in the past where they've pinched off. We've had to use the ones farther behind us. We do have some spontaneous combustion concerns, so we run a ventilation plan that addresses that. Keeps the oxygen out of the rubbleized areas. We also have to balance the atmosphere behind our seals also, and the mine ventilation boreholes help us with that also. So we have to maintain a safe environment within the mine.
Thank you. I appreciate that clarity. My apologies for not being the coal expert here yet, Jim.
So may I ask something? It's my understanding, John, that you're currently mining longwall panel 1 and doing development work in panel 2, and that panel 1's got about another 8 or 9 months, give or take. I'm just guessing. Is that correct? So you're not you're doing development mining in panel 2, which doesn't require the boreholes at this point, right?
That is correct. We do have, we aren't. it is impractical, and I believe the Forest Service frowns dramatically on trying to drill these wells during the winter, and we do too. You basically have, you've got to drill everything in the summer to get you through to the next summer or to the next August, per se. You have to do your drilling a year ahead of time in order to execute your mine plan. That is correct. So we have a window here that's available. And that's typically how we've exercised this in the past. You do your drilling this summer for what you're going to mine with a long wall for the upcoming year.
Thank you.
Thank you. I have another question, completely different topic. It would be primarily for the operator, but possibly for the environmental groups. You know, to me personally, I feel like social license to operate is critical, particularly in this day and age. We mentioned, and clearly this is a very complicated, long, much longer than just, you know, this conversation this morning. But can someone just please try to articulate what your interface with your stakeholders are on these issues, knowing that there has been a roadless rule, you know, the community of Crested Butte and the surrounding areas is one of the more prominently outspoken united communities I've experienced in mining. So it's not like this is being done in a vacuum. Your miners and your operators, and I'm assuming your engineers and general managers live within the area. What is your interface that's not in all of these legal cases with the community, and how do you explain what's going on in your decisions?
You know, I'll take a stab at that, and I'll ask Jim to follow up here. Jim, if you could talk a little bit about your work with the North Fork Coal Mine Methane Working Group and some of the other interactions that the mine has with the community, briefly.
Sorry, Jim or John?
Sorry, I apologize. John Polis is what I meant. I
Okay.
apologize.
Okay. Excuse, yeah, sorry about
That's
that.
my fault.
Yeah, we, over the last several years, there has been a working group formed within the North Fork Valley, represented by, well, first of all, Delta County Commissioner, and people from that board. There's been a number of conservation groups that attend those meetings. We have explored over the years the complexities of trying to destroy methane from the mines. There's been several proposals made. It's taken us personally several years to explore and come to find a flaring unit that we felt was safe to put on an active mine. We have at this point in time, there's one sitting on the property. We are not yet licensed to put that into service yet. And it's been through those discussions with the community that we've been able to, how do you want to say it? Find what we needed in order to keep our miners safe. And we may very well be the first mine to put those flaring on an active portion of the mine. Everywhere else that I'm aware of, the flares have not been on an active portion of the mine where men and equipment work. So, but we are actively engaged with the community in the North Fork Methane Working Group.
So that's just more related to the methane, but you don't do any sort of public updates or anything when you say, hey, it looks like we're going to, this is our next phase, summer's coming, here's our next project that's coming forth. Is there any sort of engagement there?
Well, we had a call this morning with, who was it? Western Folk Conservation Group. Our local people. In fact, the general manager was fielding that call while we were having this one.
Okay, thank you. Yeah.
If I can weigh in here just a little bit, I will point out that, you know, despite the the conservation group's involvement and in this litigation for years, we were not informed prior to the company going out and bulldozing this road. There has been very little communication from the coal mine in our direction, at least. The public, including, again, Gunnison County Commissioners, the city of Crested Butte also, I believe, has sent a letter. And there have been public protests because, again, the public was completely caught by surprise by this bulldozing of a road in the roadless area.
Thank you. Mr. Drysdale, I just want to make sure you didn't have anything else to say there.
Just briefly, in the sense that, you know, we have been very open with the state, with the Forest Service, with OSM about our plans. We did not construct this lightly. And, you know, every piece of work that's been done was staked out in advance with Forest Service representative. You'll hear more about this afternoon in the context of minor revision 446. Daniel Gray, who's a mineral resources specialist for the Forest Service, you know, both before and after the formal vacatur, was in the field saying, okay, yes, this is where this road should go. We need to adjust it here, et cetera, et cetera. So the suggestion that you know, we just went and did this on our own without any kind of consultation is just simply not correct. In terms of the larger community, you know, it's always a tricky thing. I mean, as you know, there's this litigation has gone on for 10 years. Anytime the federal agencies do anything, anytime we do anything, we get challenged in court. And so there is some caution with respect to soliciting additional decisions, final opinions, things of this nature that then spawn the next round of litigation. There have been 5, there's currently one progressing right now, 5 federal court actions in this. And this is the last operating mine in this valley. Vacatur of the North Fork exception clearly means that until it's repromulgated, there's not going to be any more mining in the 19,000 acres in this area. So, you know, this cuts both ways in the sense of we've been open about what we've been doing, and you know, our work was undertaken with very careful deliberation.
Yeah, I understand that, you know, it already is complicated and you don't want more opinions being formed, but I just truly believe that the more, particularly that the general public is educated about something that's going on and understands why you would need to build a road, that there's a safety element here, that it doesn't come as a surprise. And I think that there's a responsibility from all operators, not just the ones that are in, you know, this current conversation right now. If we want to continue being able to operate, we've got to be more transparent about what we're doing and the why behind what we're doing, because otherwise this also sets a precedent when another company tries to do something. They say, well, remember those guys down the road? They just went for it and they didn't listen. And so why should we trust this next operator? So I just urge you in the future, and I know it's difficult, I know it's a whole nother layer of effort, but this is critical effort, to educate those that maybe are not looking at every Forest Service permit, to look at your management of change processes. And when you know something's going to hit public interface, have that conversation internally and say, hey, what is the external stakeholders? How are they going to react to this? And is there a way we could come to the table? Unfortunately, right now, having coffee with someone, it just became more difficult, but we can pick up the phone, we can pick up the Zoom and field those questions and understand each other better. So that's just my advice right now. John?
Yeah, I wasn't going to say anything, but since you spoke up, I got to tell you, my heart sank and I had a tear in my eye when I saw the denuding that showed on the road and the pad that was there. I would just suggest it's incumbent on all of us to be good stewards. And I mean, you know, and the minimum requirements are no longer good enough. And I would think, I would just make a suggestion that somebody ought to get a hold of Mr. Lewis Bacon and go see his ranch down in Tercio or in Los Animas County. He put in roads and now this is private. He put in roads and gas pads that you can't see. And he took great attention to different trees. And I know one trucker said, we're gonna have to take this tree out. And he said, no, we're not. And we found a way to do that. And I just think we need to look for those kind of examples and that kind of direction and that kind of responsibility. Regardless of what it is, I don't care where we are. I think we all have responsibility to protect where we are, and it's incumbent on all of us to do that.
And I would say we certainly agree with that, sir, that, you know.
You didn't with regard to what you did to that road.
No, but I would respectfully disagree in the sense that we have always sought to minimize the amount of activity. And Mr. Poulos can explain this a little bit further. The thing you have to understand is the nature of the terrain here and the size of the rig that's required. We're drilling, you know, a couple thousand feet underground. You need a big rig to do that. We looked at an environmental review very extensively. Could we do this with helicopter rigs that wouldn't involve any roads at all? I mean, there are thousands of pages of this devoted to the environmental review documents. And I think, you know, as the division indicated, you know, we operate with very high standards and we try to minimize our impacts as much as possible. You know, and we've managed, you'll see in this afternoon that we're proposing a significant reduction in disturbance from what has already been approved by the board in permit revision 15. So John, if you could speak just briefly as to the minimization work that goes on and the size of the work that's necessary to get these rigs in there.
Yes, not a problem. What you saw was brand new construction, and you are correct with what you saw. What you didn't see was that these roads go away in a number of years, and what you haven't seen is the reclamation that's taken place there. If you'll notice, when they showed you the pictures of the pads themselves, it was mostly Gamble oak brush there. It's very tight. There's very little game movement through there. And one of the reasons why we have the Forest Service go with us when we flag these roads out is because during our reclamation process, it creates grassy areas where the elk, deer, and other animals can move back in for their calving purposes. Growing up in Paonia all my life, there was very little activity in this area when I was young. Since we've opened this up, the game has moved back in. We've actually got better hunting up there now than we did 40, 50 years ago. The land is put back to the approximate original contour, and we create grassy areas. We also have some natural fire breaks that are provided by this reclamation. So what you see here is not permanent. What you saw in the photos today was fresh stuff. There is a good reason why that timber is pushed to the side of the road, because it's used for slash when you go to reclaim the road. That slash gets pulled back up onto the reclaimed area. We use a seed mix that is approved by the Forest Service that's actually tailored to whatever elevation we happen to be at. And we've actually won awards for our reclamation. What you're seeing is one side of the story, which is brand new construction. Within 2 to 3 years after that coal's mined, those roads will be reclaimed, reseeded, and the reclamation process begins. We actually have bonds in place with the state for that, and it takes a 10-year process before the bond is completely released. So fear not, that ground will go back in probably better shape than it was as far as the game and wildlife are concerned.
And I guess the point I want to reiterate with that is, you know, I have no doubt that you have the resources to do that, right? Clearly, you said you had no NOVs, you've gotten these reclamation awards, but these actions and sort of the brashness in which it comes across is a little concerning. And unfortunately, you can do all the good work and intention in the world, and you take one step back and that faith is lost, and it takes forever to try to get it back. It's so much work. And it just, you know, to John's point too, it breaks my heart that you would have these resources that, you know, you grow up here and you love these places and one of the things I love about miners and geologists is you get into it because you love walking around in the woods. You know, you didn't want to be stuck behind a desk. None of us want to be inside today. It's beautiful. So it's incredibly unfortunate that that internal discussion didn't at some point turn around and say, my goodness, what is going to happen to our external community if we do this? And is it worth it? John?
And I just want to say that, just so that the people know, Wild Earth Guardians doesn't make my short list of responsible conservationists. I've worked on conservation since I was born in Colorado to do better things, and Wild Earth Guardians, in my opinion, exaggerates the facts very often, and it's really hard to get to where we need to go a lot of times because of them. So I don't want anybody to think I'm just siding with them. This is my own observation and my own problem with what I saw, and I just think there needs to be responsibility on all sides.
Yeah, I agree with you, John. I'm not intent at all trying to beat up on mountain coal, and I'm also not necessarily saying that, you know, the arguments made by the conservation groups are, you know, perfect by any means. It's just it's the bigger picture piece with this one, and we can go back and forth on, you know, the lease and the litigation and everything, but to me, it's unfortunate that the division felt like they had to go in there and put in this CO, because I fear that, you know, you could say whether or not it was federal or whatever, but what if they hadn't come in there? What if there wasn't an inspector in there? What would still be going on?
Well, I can tell you what would have happened. You know, again, remember, once the plaintiffs contacted us and said they had objections, we stopped work and we attempted to negotiate a way to continue, you know, not doing any work. The difficulty we ran into was that what the conservation groups were demanding was that all work of any kind cease until they had a ruling on the motion they were planning to bring to the district court. We were prepared to say, okay, we won't do any more road building until, and we have not done any more road building until the federal court rules. Where we couldn't come to an agreement is that they wanted no pad work, they wanted, you know, no drilling, anything like that, things that are not covered by the roadless rule. And that's one of the reasons why, because again, we understand that this is a controversy issue. One of the reasons why we said, even if this cessation order is terminated today, we're not going to take any further action in terms of road building until the federal court rules, precisely for the reasons you talk about. Questions have been raised, issues have been raised. We're going to get a ruling. We have to be sensitive to the construction schedule, because otherwise this mine will be shut down and these people will be put out of work. But we're not going to do any more road building. And what I have not heard at any point in any part of this thing is why that has to extend to what the division agrees were lawfully constructed roads and the pads associated with them. So we are sensitive to not getting out ahead of this and not creating further issues on this. So I wanted to make that clear.
If I can briefly respond, I mean, the reason the conservation groups would not agree to additional surface disturbance and in particular well pad clearing is because cutting trees is prohibited under the roadless rule. And so we do not believe that the company maintains that authority. And
as we talked about, that's just not correct. I mean, cutting trees is expressly prohibited. I mean, it's expressly permitted if it's doing an approved management activity, which includes coal mining under a valid lease. So again, that's something it's been briefed to the federal court. You know, the court will decide it, but you know, again, it's never been an issue over the decade of this until their current motion.
Okay. I would love to hear some other voices here. Karen?
I want to go back, and I'm not quite sure to whom I should address this question. Am I correct in understanding that the division's cessation order can be lifted if the Forest Service grants an exemption. Did I hear that correctly, or we have to wait until this goes back into court and we see what the court comes out with later on? But I thought I heard that the Forest Service could grant an exemption to this cessation. Can someone answer that?
Yeah, Jim Stark for the division. No, so originally there was an exemption for an allowed road building. That's what the district court vacated. So there is no exception. What the division is looking for is something, a definitive statement from the court, from BLM, from Forest Service, from one of these different entities, if you will, that there is still a legal right to build roads even with the vacation of this exception. We need a definitive statement that says there is still legal right of entry even though this North Fork exception has been vacated, and we don't have that. So in the division's view, the company no longer maintains right of entry. Does that help you? Sorry.
Is there anybody else that wants? Yeah, yes. Thank you. Is there anyone else that wants to speak to that?
Yeah, there's a couple things I would like to address to that. One is part of what the conservations we're talking about would be the repromulgation of the North Fork exception. It's already been, promulgated twice, and now it's gone back to them. It's certainly true. I don't think anybody's contesting that if it gets repromulgated, then there are no issues, right? The issue there, though, is that to repromulgate this exception, the estimate we get from the Forest Service is probably 18 to 24 months, and that may be a optimistic scenario. And the reason for that is because there will be many thousands of comments, there will be many arguments, there will likely be litigation again, et cetera. So yes, that would be a solution. And we spent some time with the Forest Service talking about, is there some way to, because of course, that would be easiest for everybody, right? Is there some way to do this more quickly? They said no. So that's if the exception gets repromulgated. Now, one thing I will say that Mr. Stark just mentioned that I thought was very interesting is, and it wasn't clear to me from the cessation order, was that the statement that the division appears to be looking for is a statement from the BLM or the USFS. I think we can certainly, like I said, I've explained the reasons why they've been, why they haven't wanted to do anything of that nature forward. If that's what you're looking for, because again, it's typically the person who holds the lease that provides the lease documents and the statement of entry. But if what you're looking for is a statement from the agency to that effect, then we would certainly, that's the first I've heard that, and I can certainly, we can certainly inquire further on that end as well too.
Has that, Mr. Stark, has there been any attempt to approach the agencies about that statement, or have you not gotten there yet on that?
I'm sorry, was that question for me, Karen?
Yes, I'm sorry, Mr. Stark. Yes.
So we contacted both Forest Service and BLM back, don't quote me on the date, it was before we issued the cessation order. So it was the week of the 15th, sometime in there, and they were mute on everything. They wouldn't tell us basically anything at this point. So at that point, and again, I'm sure it was because of the ongoing litigation. So we got nothing from BLM or Forest Service. We were trying to figure out what their stance was, where they fell on this. And again, we felt that if we didn't do something, we were abdicating our responsibility as an oversight agency and allowing something to happen that we felt was in clear violation of the law. That's why we issued the CO. We determined that they didn't have right of entry, but we felt that we needed to act on this.
Okay, all right. Thank you. I guess this is maybe this is a horrible example that it has reached the point when entities cannot get together and work it out, this sort of thing happens. And not only do you have magnificent scenery and scenery that we need to be there forever, being somewhat jeopardized and could be future jeopardized. We also have 300 plus people in an area where there aren't a lot of jobs. You take those people out of work and you suddenly are starting to look at something like Appalachia. Make no mistake, there's not a lot of jobs that are going to come in and take those mining jobs, take up the slack that those mining jobs had. I just fear that everyone I recognize, first of all, the reclamation that was in plan. I wish the mines would have come forth. We have done this on my properties. The reclamation, I know what it has worked. I can certainly stand behind the mines and say, you're right. You are exactly right on with what you're doing. I wish you would have included some of those pictures just so other people who might not have seen that sort of reclamation work, what it can look like. But that still doesn't come to the answer of the problem that is before this board and before everyone who's sitting there. And as I say, it's not going to be a win-win situation, I fear. And I hope that this example has reached, it's accelerated. I sat on the board when it came a few years back, we had issues. And it accelerates each time. And at some point, you folks are going to have to sit down and sit in each other's chairs and say, what would you do in that situation? But you can't go much further along and not just do irreparable damage to both the mines as well as to the conservationists.
Thank you,
That's all
Karen.
I have to say.
Thank you, Karen. I have a question possibly for the division. Just another point of clarification on this roadless rule, and if it really, if it cuts off right of entry to the mine, or if it's just about the right to cut new roads, because cutting of new roads, prohibiting that still kind of cuts off the mine because you don't have any way to ventilate it. So whether those are unintended consequences within the rule or intended consequences, I'd love some clarification on that.
I'll give you what is probably not the exact answer you're looking for, because I am no expert in Colorado roadless rule. You do have two attorneys on this call who I think are more experienced with roadless rule than I am. My understanding, though, is the roadless rule, it's not specifically something the division, did analyze in its kind of issuance of the CO, but it does preclude the cutting of trees, which needs to occur at least in the road building, arguably in the pad construction. But that's my understanding. As it relates to the ability of the mine to continue to operate, I think you heard from Mr. Polis about that, and Jim can also give some further information on, again, this CO as drafted, how it impacts the mine's ability to continue to operate. Please note that it was crafted with the purpose of keeping the mine inactive, or in an active status. So if you're looking for further information on roadless rule, the other attorneys may be able to chime in on that, but I think that Jim Stark can give information on impacts of this on the mine.
Thank you.
I mean, I guess I would just say that the roadless rule itself in general is close to a blanket prohibition on road building and tree cutting. And there are specific exceptions that get around that general prohibition. And the North Fork exception was clearly intended to allow coal mining in this area because the understanding was that roads that type of coal mining could not occur absent road building. And so absent an exception to the Colorado roadless rule, there would be no way to continue to mine coal in this area. And so that's essentially why when you take away that exception, you take away that right to build roads and cut trees. I think, again, the unintended consequence of sort of the order of these operations and the fact that the vacature, again, it's very clear that none of this activity ever could have happened if the exception to the roadless rule was not treated as if it was lawfully in place. The reality is now it has been removed, and it has been removed since it was ever promulgated. It was never lawfully in place.
And I would actually agree with much of what Mr. Timmons has just said there. It is a general prohibition on road building. It is a general prohibition on tree cutting. But that's why there are a series of exceptions. And it is true that this lease was issued under the North Fork exception, which is now no longer in place. But the lease was left in place. If the 10th Circuit had said we're going to vacate the lease modifications, we wouldn't be here. We'd be, all right, the mine is going to close down in a few months. Actually, the mine is going to close immediately. Our people are going to be out of work. It'd be a clear question. We'd be asking for refunds of the bonus bids that we paid the federal government, and the North Fork would no longer be a source of coal mining. But instead, the 10th Circuit, and they were very clear about this, in their equitable discretion, left the leases in place. Because the lease is in place, that then raises the question of, okay, are we now eligible for another exception? And in particular, this is both road building and tree cutting. And I won't get into, again, rehash all the stuff we've talked about both before, but that's the rub we've got here is we've left the lease in place. As Mr. Timmons acknowledged, we need the roads in order to continue to operate. We're going to run out of coal in a few months. And at that point, we'll have to shut down if this isn't addressed in some way. The North Fork exception, we've been told, can't be repromulgated in time. And so the issue really is, all right, are we going to be allowed to do this? At a minimum, if the cessation order is modified so that it does not cover the roads that were built before vacatur, which again, the division has said today were lawfully constructed, then that buys quite a bit of time for the mine. Again, we think it should be, for the reasons we've said, it should be entirely terminated, but at least modification along those lines will substantially extend the life of this mine while this gets sorted out. So.
And just to confirm that initially in your presentation, you had asked for a narrowing of the scope of the CO to include use of the roads built to date, previous to this, the use of the pads and the pads that were developed, drilling of the methane vents, and use of the longwall SS2 road, correct?
Yes, the one thing I'd add to that is we've built 2 pads and there are 3 more planned, which we think is perfectly allowable. And we would like to be able to do that as well too. And if the board could come to that resolution, then there would be no need for us to press these jurisdictional questions, et cetera, at least with respect to the CO. We're going to get clarification from the court at some point, but that would address the immediate issue.
Do the pads, you've got 2 existing pads, you have 3 more that you need to build. The road is already built to access those pads?
Yes, no more work is needed on the road.
But you would need to do some clearing in order to build 3 more pads, correct?
Yes, a total of about 1 to 1.5 acres. There's the first 2 pads. As you'll see on the map, that the first 2 methane ventilation boreholes, there's always 2 that are close together. And that's because when a new panel is started up, there's some uncertainty about the rate and amount of gas. It's possible those could be merged to reduce impact further. It's one of those things we're going to have to make an assessment on. It's going to be no more than 1.5 acres of additional work for those pads. And it could be as low as 1 acre.
Thank you. Mr. Polis, you said you've got how much work left in Longwall 1? How many months?
there's several months left. Yes, the exact determination is all driven by the shipment.
Okay.
Coal face.
So just based on demand. And then, so this is typical of how you do your operations. You're sort of finishing up one long wall, developing the second one because it takes,
Months, if not years, to develop the next panel. Yes, ma'am.
and then we throw in winter.
Yep.
Okay. Yeah, this is so much of a timing issue here as well, right? Because do we really know when?
Hey, Nell.
Yeah.
Looks like we lost John. We need to go ahead and get him back on. Just pause everything
Thank you.
so that we can get him back on and have a quorum.
Thank you.
Okay. Let me see what's going on, guys. See if I can't get him back on.
Thank you, Chuck.
Mm.
Now, while we're waiting, I'm gonna take 3.
Sure. If anyone else needs to step away, feel free to go for it. Make it quick.
I'm trying to reach him, but he's not answering his phone, so I'm assuming he's trying to get back on.
Okay, just let us know, Cami.
I will,
Thank you.
I will for sure.
There he is.
Yep, there he is.
Okay, we let Tim take a quick break, so we'll let John get settled.
Sorry, John, that was me trying to call you.
I'm back in.
Yep.
You're back in.
Okay.
Okay, we've got everyone. We've got Tim, we've got Karen. Does everyone
When it's appropriate,
go ahead, Karen? What?
no, go finish out. When it's appropriate, I do have a question for someone, but I think there's someone ahead of me, or maybe it's you in the question.
No, that's fine. You know, I want to make a clear distinction between, you know, testimony and going into deliberation. So if we feel like we've heard the testimony, we've heard the closing statements, we've asked the questions of the closing statements, if we can go into deliberation on this matter with the board.
I have
Chuck.
one question before we go into deliberation, if that's
Sure.
okay.
Sure.
Should I go ahead now?
Yes, please.
Okay, John,
Yes.
or Mr. Poulos?
Oh,
Yes, ma'am.
I'm sorry, sorry, the other John. Talk to me a little bit about the reclamation that could possibly occur while on those pads, while that long wall is being used. Can you only reclaim at the end of the whole mining activity, or can you start that reclamation in some ways on those pads and roads even?
Yes, ma'am. The reclamation is done contemporaneously. Once
What
that,
does that mean?
that means that each season we drill and each season we reclaim different roads and pads in other areas. Once the mining has been completed for this second panel in the Sunset, then the next panel would be developed and mined, and we usually leave those roads for a year or so in case we need to balance our ventilation with an MVB. But by the time we get the next panel built, then we come back in on that drilling season, and with our dirt contractor, we go in and we pull the roads back, reseed them, put in the proper erosion controls, and start our 10-year reclamation. So it does take some time. The roads are usually open between 2 to 5 years, somewhere in there. Like I say, we are in, that's one of the things we've done with our dirt contractor this season, because our drilling has been halted. We've moved over to do the reclamation portion of what we normally do during our drilling season, and we're just about complete with that now. Is that answering your question?
That answers part of the question, and I'm going to continue with another one. How long does that mining of a long wall last?
It depends entirely on, first of all, how long the panel is, because the panels have to, well, we can only mine what Mother Nature gives us, okay? These are shorter panels than we've had in the past because there's no reserve farther to the east, okay? It also depends on how quickly you sell your coal, because we're only allowed to store so much on the ground outside. So we really can't mine it any faster than the trains come to take it away. And that's all driven by market sales. As an example, you can run through a shorter panel 12 to 14 months. A longer panel may take 16 months. Just depends on what the coal market is.
But that coal would then be sitting on that pad?
No, the coal never sees the surface that you saw today. The coal is conveyed underground for another 7 miles before it comes out the mouth of the mine, clear over at the North Fork River. And we have permanent surface facilities to handle that coal and put it in a train. What you're seeing now is 7 miles to the south of where the miners actually enter the mine. So it's a long ways from there. And the disturbance that you saw today will be the only disturbance from the coal that you see. And it was unfortunate we didn't have some reclamation pictures for you to see.
Yeah, I wish you would, because as I said, I work with this all the time and I know what can happen, and you're right on with that. Let me ask you, and you may have answered this question and I just didn't pick that up. While you're mining that panel, can any reclamation be occurring on the pad, or does that interfere with the structures that are there?
Yeah, the pad itself is used later on to set the exhauster on. So we have to be able to drive to that pad on usually a daily basis to make sure that everything is safe and working properly. So the road and the pad gets used until it's time to reclaim it, which could be the 1 to 3 years, 1 to 5 years, depending on how fast you mine the panel next door. So there is probably not. What we do is we maintain the erosion controls that SMCRA permit has in place for us during that time period. So we do have to make sure that our drainage stays in place. Every spring, once the snow's gone, we go up there with the backhoe or whatever equipment's needed in order to repair any slumps or things that have happened over the winter. Keep in tune with our SMCRA permit. So
Does that exhauster, is that a unit, or is the exhauster several of those, I want to say pipes, and that's not quite the right word.
the exhauster consists of 2 units. It's a small skid that's probably 8 feet long, maybe 6 feet wide, and then there's another trailer mounted exhauster that's hooked up to that. So you have 2 units on each pad. They take up roughly 2 parking places, if it gives you an idea of how much space is taken up on the pad. The reason the pads are built to the size they are is to accommodate the drill rig and the drilling functions. It's a much smaller footprint for the equipment once you move it over to actually exhausting the methane.
So the drilling rig is sitting on that pad then?
Only while the hole is being drilled. And it takes about a week to drill a hole, and then they move to the next pad, drill the next hole. And once the drilling season's done, that drill rig goes away. It doesn't come back until next season's drilling.
Okay, then it would come back to the same pad though.
No.
Right.
Once you drill one hole on one pad, you're done.
Okay, so you do have room on that after that drilling rig is gone to start some reclamation, even if it's just grasses initially. Am I correct?
Well, the pad could be made smaller, yes.
No, I'm not saying the pad needs to be made smaller. I'm saying once the drilling rig has gone, then you have a very large pad sitting there with a small exhauster units, which are very important, make no mistake. Can't some seeding be done on those pads even once that drilling rig is gone?
What you saw, interim reclamation is done. The seeding and mulch are actually in place right now on the outslopes of that pad. Once the drill's gone, then that is maintained. We don't actually shrink the size of the pad. It's a possibility that it could be shrunk.
I'm just saying, cannot some of that disturbed soil start to be reclaimed, with seeding mixture?
One of the things that's mandated by the SMCRA permit is reclamation to what they call approximate original contour. And in order to do that efficiently, you'd need to do the whole pad at one time to put it back to that contour before you start reseeding. Now, what we have disturbed that's not actually on the pad itself gets reseeded and mulched to hold it in place during the time that we use the pads.
Okay, that answered my question right there. All right,
Okay.
thank you very much. I appreciate that.
If I may, I will also point out that we actually do have some photographs of the venting equipment and the state of the pad sort of when they're in active use that show up at pages 656 and 657 of the administrative record. Those were photos that were included in one of our declarations taken by a member of our group. If I may also make sort of one final point, I guess going back to I think something that the chair was mentioning. I guess I appreciate the desire in general to find a compromise solution. But I think in this circumstance, the compromise that Mountain Coal has proposed would essentially reward them for bulldozing first and asking questions later. And I think that does undermine that social license to see that type of behavior rewarded by this type of body. I will also point out that it's been since March that 10th Circuit decision was issued, and Mountain Coal has significant additional private lands that are not subject to the Colorado Roadless rule that could have been being prepped over the course of this summer. In addition to other national forest lands, I believe as Mr. Drysdale indicated, that we're not subject to the roadless rule restrictions.
Mr. Drysdale, if you have a brief response to that, that's okay, but I want to stay on topic.
No, I don't think I need to respond to that.
Okay, I want to respect people's time and really move into deliberation of this matter, please.
Madam Chair, before we go there, I've just got one
Sure.
quick question. Process-wise for probably Mr. Stark or Mr. Fugate. On a cessation order, remind me how this works. If we do uphold the CO, can you, if you determine there is access, legal right of entry, can the division remove that administratively, or does that have to come back to the board?
Yeah, I can field this, Tim. If the company satisfies the abatement, so basically proves to our satisfaction that they have legal right of entry, we can administratively terminate that. We have that authority on our level in the coal program. So it would not need to come back to the board.
Thank you for that question, Tim.
Yeah.
Okay. Deliberation. You have some thoughts, John?
Yeah, a little bit. It's been some interesting questions, and I don't know. This is a tough one. They all are when we get to here, but I don't know. I agree that I think I'd have to agree that they lost their access. So the 10th Circuit's it's a pretty moderate court. I mean, they don't swing too far left or right, so that usually they're pretty much upheld. So I have a lot of faith in the 10th Circuit, but so I don't know. I mean, I'd like to hear some other thoughts.
I'll go. Tim Mock here. I think that one, this is obviously a tremendous legal quagmire in some respects and very complex to sort through. I appreciate that the division is looking for definitive legal right of entry. I'm not certain that the arguments have satisfied me that those exist. I don't think that the decision right now is the end all be all to this. I imagine it sounds like we're still waiting for a federal court decision. So I intend to uphold the CO.
Thank you, Tim.
Yeah, Karen Utterback, Norman. I was somewhat intrigued by Mr. Timmons' last comments about we want to be sure that the coal company cannot do things cannot continue business or continue its operations after decisions have been made. And it's kind of like, we're going to slap your hand. I look at the 300 people, the plus employees, and you shut that down, and the way this economy is now, I think there's some other factors here. I agree exactly with what Tim had to say, but I think we have to extend this a little bit longer and look at some indirect consequences of just saying, all right, we'll let the division's order hold, or we will support the division's order. I think there are an awful lot of other factors and people that could be drastically affected by this. And so though I may agree with the division on what it has done, and it certainly has done it as a right of entry, I think we have other entities that are greatly impacted by this.
Thank you, Karen. John, following any of those, did you have any other thoughts that you wanted to weigh?
You know, I don't want my emotions to get involved here. I do think that, you know, because of the hearing, they rushed in there and did this road work, which is, you know, which, I mean, and then they came back and said, you know, we did the roads, so now we can use them, and we did it during a legal period of time, and did them legally, and that's probably by the letter of the law true, but, you know, I don't know whether it was an honest approach to it, but I don't know. I totally, Karen's really thoughtful about this stuff, and I appreciate it. But and I appreciate the history of the mine up there that was working with us, and I think they've been pretty dutiful about being good citizens in most cases. And it's tough when you're in mining. I know that, and so I don't know. I haven't really made my mind up yet, but I legally I think I think they don't have, I don't think they have access right now, legal access. Maybe they can work it out, and maybe that should be what happens. But right now, that's just kind of the way I see it.
Thanks, John. Did someone else have? Is that my echoing, or is someone else trying to say something? Okay. So clarifying again that should some other elements fall into place from either federal Forest Service, you know, court things, that there's an administrative way for the division to work with the operator to release the cessation order, should that happen and that timing makes sense. Am I correct in understanding that from the division? That's something the division is able to work with the operator in an administrative sense to do, should we choose to move forward with upholding the cessation order currently.
Just want to clarify, I think the testimony's been closed. Do you want us to answer that or not? I don't want to get out of process here.
No, I don't want to get out of process, but
No, I can just, I mean, that was what Jim said.
Okay.
Yeah, that administratively it can be resolved, so.
yeah. I just want to clarify what I'm understanding before I say it. Okay. With that information, is there further discussion? Is there anyone who is interested in entertaining a motion to this?
I'll move the board uphold the cessation order CO 2020-001.
Thank you, Tim. Is there a second?
I'll second it.
Thank you, John. All those in, oh, any discussion? No discussion. All those in favor, please signify by saying aye.
Aye.
Those opposed, same sign.
Aye.
Okay, one opposed. Thank you. Okay, the motion carries. Thank you for this discussion and thoughtfulness on the matter. Chuck, anything else before we set the stage for agenda item 8?
Not unless, I mean, it's 12:30, and so I don't know if you want to take a break first or start things off and then move into it, or where everyone's at. So
Yeah, I guess I do intend to take a break before we get into 8. I just wanted to make sure that while we had all the faces on the screen, am I correct in understanding that it's all the same people here? Yeah, we're not waiting for someone else to come in. There's no one who doesn't intend to be here for item 8.
Yeah, not that I'm aware of, and I don't know that we've got any, we already resolved the ProHack application for both
Yeah.
matters, so I'm not aware of any kind of preliminary things that the board needs to handle before moving into item 8.
Okay. Well, we have 90 minutes on the agenda for this one. Clearly, we're capable of going over our suggested time as shown by this morning's conversation, but it's important to understand everything, and I appreciate everyone being here. So does 1 o'clock really give everyone enough time to grab a bite to eat? Do you need 1:15?
Let's do 1:15.
1:15, John?
Yeah, let's do it.
Okay, sounds great. We will see everyone back here at 1:15 then. Thank you.
Thank you.
I want to make sure we get Karen on. Hey, Cammie, any word from Karen? She's not having trouble or anything, is she?
I have not heard from her as of yet.
Okay, we'll give her.
And I'm watching to see if she shows up in the, to
Yeah.
come back on. So there's Jenny. There she is.
All right, I'm looking at names and faces. Am I missing anyone?
I don't see Jeff.
Okay.
Lee, is he in the room with you?
Jeff, he just stepped out. He'll be back in a minute or two, I think.
Okay. I see Russ's name, but is Russ here?
I think he's been blacked out the whole time. So
Okay. I just never know if there's someone actually behind that blacked out. There he is.
there he is.
All right, we've got Karen, we've got Jeff Step. Okay. Everyone feel like we're good to proceed here with agenda item 8 regarding a request for a formal hearing for mine revision 446. I just want to make sure, we talked about the ProHack for Mr. Timmons in agenda item 7. We are fine to proceed. We made a motion on that prior to this. Everyone's okay with that carrying over to agenda item 8?
No, did we want to wait for Jeff?
Oh, sorry. I thought, oh, it's Jim that's in the room with Lee, not Jeff. Okay.
Well, I think Jeff had just stepped out for a second, so he should be right back.
Sure.
There's Stark. There he is.
Sorry about that. I didn't realize people were waiting on me. My apologies.
All right, now go for it.
Okay, so Jeff, we were just saying that we're starting off here with item number 8. And just a conversation confirming that it was fine proceeding with, we've already made a motion regarding Mr. Timmons for agenda item 7, for him to continue to represent the parties under ProHack in the motion. We don't need to make another motion.
I think that's correct. If you're, I think Chuck, yeah.
Yep. I just
Yeah.
want to confirm.
And similar to the previous hearing, we did not negotiate an order between the parties, but I think we could probably follow the same order as the last hearing unless Mike or Daniel, if you've got any other suggestions on just the hearing order itself.
I think that's fine. I believe that, I thought that Jeff and you and I had discussed the conservationist going first as sort of the kind of plaintiffs in this appeal, but we can go either way.
Going first after division's presentation, you mean?
Right, exactly.
Right,
Yeah.
right.
Sure. And you want to continue that pattern also in closing?
That's fine.
Sure. So division, conservation, operator. Please speak up if I'm out of line. I forget any orders here. Chuck, any? You okay?
Yeah, no, I think that's fine. So division will do an introduction and then interveners will do the presentation, then division operator for presentation, and we'll just carry that through.
No, if the division could do introduction and their presentation at the same time.
Yeah, that's fine.
Okay.
Yeah, we'll do introduction and presentation first by the division. Then do we call it, how would you like to be referred to, Mr. Timmons? Conservationists, for like sake of clarity?
Conservation groups is what we've been
And
using.
conservation groups followed by the operator, and then same order into rebuttal, same order into closing statements. Good?
Yes, I think that's fine.
Okay. Well, then I will hand it off to the division.
Okay. While I set this up, can we just do a bit of a sound check here? Will someone confirm that they can hear me clearly?
Yes.
Yes.
Okay, good. All right. So I'm trying to share my screen with you. Does that look good, Jeff?
I think it's good. I can't hear them on questions, but that's
Okay. Okay, good afternoon, everybody. My name is Lee Simmons. I'm an environmental protection specialist with the division. I've worked here for about 8 years, and I've been the lead specialist on the West Elk Mine for approximately the last 5. I'm going to try to keep my presentation fairly brief, but I would encourage you to stop me if you have questions as I go. I'll briefly describe the mine. I'll describe minor revision 446 and tell you what it does and what it doesn't do. I'll talk about the types of revision that are allowed by the coal rules, and I'll describe the minor revision process. And then I'll turn to the conservation group's objection letter and go through the issues that are raised in that letter one by one. You've seen this slide already this morning. It shows the location of the West Elk Mine. It's a large, active underground coal mine in Gunnison and Delta counties. The pink line on this slide shows the approximate permit boundary, which includes almost 20,000 acres. The affected area, that is the land that's undermined and potentially subject to subsidence, is almost 16,000 acres. The surface disturbance is much smaller, less than 600 acres of approved disturbance. And for the underground mine, that includes facilities, refuse piles, equipment storage, and in the case of the West Elk Mine, as we've heard this morning, mine ventilation, borehole pads, and the roads to access them. So minor revision 446, MR 446, was submitted June 13th, was found complete on June 15th. And this text is copied. This is the long description that was copied from the completeness letter, and it summarizes what MR 446 does. MR 446 seeks to reduce the total number of mine ventilation boreholes on longwall panels SS3 and SS4 by 7, and to revise the locations of a further 14 pads, 1 on SS2, 7 on SS3, and 6 on SS4. The layout of MBB access roads is also revised and reduced. More than 17,000 linear feet of road are proposed to be eliminated. So an adequacy letter was sent following the completeness review and responded to immediately. The decision to approve the revision was made later that same day. An objection was received from conservation groups on June 19th, was subsequently updated on June 25th. So stepping back, the coal rules, which I understand the board is less familiar with, allow for 3 types of revision to a permit: a minor revision, a technical revision, and a permit revision. So a minor revision is defined by Rule 1.04, parent 7.3. It means a modification in permit revisions to reflect minor alterations in the location of roads or other facilities within the permit area. I won't read the rest of the text. Importantly, it shall not cause a significant alteration in the permittee's reclamation plan. The process for a minor revision is summarized on this slide, and it's defined by rules 2.08.4 and 2.07. So the division is in the process of transitioning to a electronic permitting model, and West Elk is beta testing that. They're one of the guinea pigs for the new model. So they're trying to submit their revisions through the e-permitting portal, although the division is still working out some bugs with the software vendor. And so there have been some issues, and it's something that I'm paying particular attention to, not for any, not because of the nature of the revisions, but because we're interested in making sure that the process is working smoothly. So in this case, the submission was through the e-permitting portal, but Kathy Well actually emailed a copy of what she had tried to submit, and that was how we got it into the system in this case. I won't read everything on here, but you'll note that there's a period for a completeness review and another period for an adequacy review. Often, depending on the revision, it's not unusual for those reviews to be conducted concurrently, and a decision can be made immediately in some cases. You'll also note that there's no formal comment period, and there's also no proposed decision. So a technical revision or a permit revision, the division would propose its decision and allow a period for comments afterward. But in the case of a minor revision, which, as we've already discussed, is much more limited in its scope, there is no proposed decision, there's just a decision. And there's no comment period, but there is a 10-day period following the decision where affected parties can lodge an appeal, and that's why we're here today. So let me pause there and ask if anyone has any questions on anything I've covered so far. I'm hearing no questions, so I'll continue. And now I'm going to refer to the objection letter that was received from conservation groups on June 25th. In their letter, the objectors made 4 assertions. Firstly, they asserted that the division's completeness finding was premature. Secondly, that Mountain Coal Company lacks a legal right of entry to build roads within the Sunset Roadless area. Thirdly, that multiple newly approved road segments are not needed to support Mountain Coal Company's coal mining activities as required by the North Fork exception. And finally, that MR 446 violates Mountain Coal Company's lease terms because it allows crossing of riparian and floodplain areas despite available practical alternatives. So I'm going to go through each of these assertions one by one. Firstly, the assertion that the division's completeness finding was premature is wrong. The meaning of the term completeness has been explained to conservation groups multiple times, verbally, in writing, and indeed during the October 2018 board meeting. A finding of completeness is a threshold administrative determination which allows the division to commence a more thorough technical adequacy review. The MR 446 application satisfied the criteria of a complete application. So I don't intend to talk about this any further. The second objection was that Mountain Coal Company lacks a legal right of entry to build roads within the Sunset Roadless area. I realize that we've discussed this at length already today, so I'll keep my comments fairly brief. With respect to the right of entry, there were events took place in rapid succession. So MR 446 was approved on June 15th. The district court order to vacate the North Fork exception was also entered on June 15th. Cessation order CO 2020-001, which prevented any further disturbance in the Sunset Roadless area, was issued on June 18th, 3 days later. The provisions of the cessation order trump all previously permitted activity in the Sunset Roadless area, including but not limited to MR 446. So although MR 446 has been approved, it may not be implemented unless and until the cessation order has been abated, at which time the legal right of entry issue will have been settled. If the determination is made that Mountain Coal Company does not have a legal right of entry, the cessation order will remain in place until such time as a revised mine plan is approved. At no point will the division retroactively rescind or request that the operator withdraws a previously approved revision. Just to elaborate, if the cessation order remains in, if the legal right of entry question is settled by the courts or the federal agencies, and it's agreed upon that Mountain Coal Company no longer has a legal right of entry, their existing approved permit terms, the aspects of their permit application packet that were approved with revisions such as MR 446, but a host of other revisions as well, will remain in the record, but new permitting will be required to approve a new mine plan, given the new conditions. I'm going to move on from this question unless, from this issue, unless anyone has questions. Okay. The third assertion that was made, that multiple newly approved road segments are not needed to support Mountain Coal Company's mining activities as required by the North Fork exception. So no new roads were approved with MR 446. The disturbance associated with the MVB pads and roads in the Sunset Trails area was approved with PR 15 in 2018. No new disturbance was approved with MR 446. In fact, 7 pads of approximately ½ an acre each and 17,000 feet of road were eliminated with MR 446. So a reduction in disturbance. This is not unusual. Minor revisions are customarily used by West Elk or by Mountain Coal Company to update the permit application packet with revised pad and road locations as mining progresses and conditions change or are better understood. The precise details of the road and pad layout is determined in cooperation with Forest Service staff where they occur on Forest Service land in the field. So US Forest Service staff actually spend the time, they don't review it from their desk, they're actually in the field flagging the locations with the mine staff. And conservation groups are aware of this, as it was explained in the field with them during a tour that took place in June 2018. I'm going to spend a little more time on this third issue to give you a little background to it. So this slide shows a timeline from the submission of permit revision 15 in March 2018 through to the present day. And it shows the submission and issuance date of the revisions that have occurred that contemplate mine ventilation boreholes. So PR 15 approved the construction of 43 MVBs on panels SS1 through SS4 with a total disturbance of approximately 54 acres. And I'll just waggle my mouse cursor over here. I'm not sure if you can see it, but that's on the scale that we're looking at, that's a pretty long period of review. Since that PR was first submitted, we've had 1, 2, 3, 4, 5 minor revisions that discuss MVBs, and they all do a similar thing. So MR 429 updated the layout of MVBs on panel E8. MR 435 updated the layout of MVBs on panel SS1. MR 441 dealt with panel SS2, 444 on panel E14, and finally 446 updated the layout of MVBs on panels SS2, 3, and 4. None of these minor revisions increased the disturbance or impacted the reclamation bond. I'll show you how it works. On your screen, you can see an aerial image. This is standard stock Esri imagery. It's several years old, but this is what comes in as a base map if you use any ARC map products. There's a blue rectangle that's projected on top of it, just to give you show you an area of interest. The blue rectangle is going to stay, and I'm going to layer georeference paper maps on top of it. So to begin with, you can still see the blue rectangle, I think, faintly, but you can see underneath that a scanned copy of the map that was approved with PR 15. It shows 4 longwall panels projected with a faint red line. SS1 is at the top, SS4 is at the bottom. The MVB pads and roads are laid out above the panels. And as you saw in the earlier presentation, the heavy black dashed lines are also projected, and those show lease boundaries. So the federal coal lease is in the center and on the right of your screen. Those are federal coal leases. The area on the left of the screen is privately owned. So MR 435 was submitted, which revised the layout of MVBs on the first panel, SS1. And the reason that these types of MRs are submitted is because during development mining, the company found that conditions or the coal quality deteriorated further to the east. So the panel length was reduced and fewer MVBs were needed. The previously approved locations are shown as black circles with no fill and black dashed lines for the road locations. And then the proposed revised pads are shown in yellow with blue lines for the roads. So there's a reduction and a reduction in the number and a revision of a minor revision to the layout of the remaining pads and roads. So now I've got all of the same stuff and I've laid another map on top of it. So this next map shows what was approved with MR 441. It's a similar situation. The SS2 panel was shortened because of mining conditions. The MVBs that were approved are reduced and revised. The next slide shows the same thing. This is the map that was submitted and approved with MR 446. Most of the changes are to panels SS3 and SS4. There's just one pad that's affected on panel SS2. It shows a significant reduction in disturbance. And while we're looking at this slide, I'll just emphasize that the actual locations in those federally owned areas are determined in cooperation with the landowner, that is the US Forest Service. Now I'm going to move on to the final assertion that was made in the objection letter. I've abbreviated it on the slide, but MR 446 violates Mountain Coal Company's lease terms because it allows crossing of riparian and floodplain areas despite available practical alternatives. So neither the division nor the board have jurisdiction over the terms of a federal coal lease. This issue is outside of our remit to comment on. All I would say is that Mountain Coal Company maintains a road use permit with the US Forest Service, and just stress one more time that all of the planning for the construction of the roads and pads is done in cooperation with Forest Service staff from the Paonia Ranger District, who are in the field for a significant amount of the construction season with mine staff, and who attend bond release inspections with the division and offer concurrence when we propose to release disturbance from reclamation liability. That concludes everything that I wanted to present to you. I'll pause. I'm not sure if any of my colleagues want to chip in with anything they think I've missed, or if any of the board has questions that I can answer for them right now.
Lee, I'll just ask if you can not share your screen so we can see more faces. That's helpful with the discussion period.
Okay.
Thank you. Questions from anyone? Okay, hearing none. Introduction and presentation by the conservationists.
Thank you, Madam Chair. For the record, again, my name is Daniel Timmons, and I'm here on behalf of conservation groups, Wild Earth Guardians, High Country Conservation Associates, or Advocates, Center for Biological Diversity, Sierra Club, and Wilderness Workshop. And again, my colleague, Ted Zukowski, is also here with me as well. So starting off with the legal right of entry question. My understanding from Mr. Simmons' presentation is that he would agree that to revise a permit, the company needs to establish a legal right of entry. In this case, as the board just determined in our prior proceeding, Mountain Coal has not demonstrated a legal right of entry after the vacature of the North Fork exception. That exception was vacated in the morning of June 15th. The email I have is 8:35 a.m. And as Mr. Simmons indicated, it was later in that day that the permit revision was approved. So by the time that permit revision was approved, the North Fork exception was clearly stricken from the books. I believe that that lack of legal right of entry should resolve this matter. Absent a legal right of entry, a permit cannot be approved, or a permit revision cannot be approved. I think that also goes essentially to the premature decision part, that there was no sort of the dispute regarding the potential issue regarding the legal lack of legal right of entry was clearly before DRMS. The agency knew that this issue was sort of pending before the district court. And then when that district court order, my understanding of what the board has just determined and what the staff have presented is that that was sort of a trigger point, that legal right of entry at that point was clearly absent. So I don't think that it's appropriate to say that decision was somehow mooted by the cessation order. As we indicated, that cessation order could be lifted, and sort of, the decision at the time the decision is made, the evidence before the staff, the evidence before the agency needs to be the basis for the decision. And it's clear here that at the time of that decision, the North Fork exception was vacated and nothing had been presented to the division to assert a legal right of entry onto the Sunset Roadless area. I feel like that's pretty straightforward. I'm happy to entertain questions just about that, but I really do feel like that's a pretty straightforward position or argument. And so I really had not prepared a presentation on that, but I will now go ahead and share my screen and get into the other issues that we also believe are before here. Again, we really do think that essentially the board's prior decision should, oops, I went back to the beginning. Oh, sorry about that. The board's prior decision should have, okay, I'm really bad at this, should effectively resolve this case or this appeal. Play from current slide. Again, my apologies. But getting to the next issue, the question of whether roads were needed. Again, even assuming that the Colorado roadless rule, that the North Fork exception was still in place, somehow that was still there, a temporary road would be needed, needs to be needed for coal exploration. And here, this is the entire narrative description of the purpose of this revision. Reduced and revised longwall panels, SS2, SS3, and SS4, MVBs, and roads. That's the detailed description. There's simply no evidence in the record indicating that these roads were needed. Now, Mr. Simmons has said that there were no new roads that were proposed as part of this application. But for that, I think we should just go to this map again. So again, the dashed black lines here were what was removed from the previously approved permit. And then these roads in blue were what was newly approved. And there's a couple of places that I want to focus on. But first, we certainly, we recognize that there was a reduction in the total roadway and the total disturbance. But again, that was, as Mr. Poulos, I believe, indicated or stated very clearly in the prior hearing, the reason those were removed is because there were no reserves found to the east. And so removing those roads was not an act of goodwill or an act of sort of an environmental-based decision. It was simply there was no mineable coal reserves in that area, so it made sense to take those off the books. But what was changed in particular are two of these new road segments, particularly this one from the north running all the way down to SS3-2 and SS3-1. Previously, there was no road segment connecting these this section of these panels, these MVBs, all the way up to this road segment. And there is nothing in the record to indicate why these these MVBs, these pads here, could not be connected directly to the west to SS3-3 as was previously approved. And I think the fact that this roadway was already previously approved indicates at least a presumption that that is a practical route to take that roadway. And again, there needs to be evidence before the division at the time it makes its decision showing that there is a need for that road. Again, similarly, this road from SS3-1 south to the MVBs on panel 4, SS4-2 and SS4-1, this roadway, this lengthy segment here, again, there was not previously a road connecting these two areas. If you look, there was a road that went way east, but did not connect north, connecting panels 3 and 4. It's accessible to the west off of the private land from this roadway here. And again, given the previously approved road connecting SS4-2 area to SS4-3 that goes this way, again, there's no demonstration in the record that that new road segment is needed, which again is particularly problematic given that this new road segment crosses South Prong Creek. And that's particularly problematic because of the coal lease stipulations. And this is coming from the coal lease. It's in the record, Bates number 728. And I will pull out the critical language here. That surface use or disturbances will avoid riparian, wetland, or floodplain areas and a buffer zone surrounding these areas unless no practical alternatives exist. Now, Mr. Simmons has indicated that the division lacks authority to interpret the coal lease. As we discussed in our prior hearing, the division lacks the authority to issue a coal lease on federal lands. But under the cooperative agreement, the division is plainly given language to interpret the terms and conditions of the federal coal lease and to enforce those as part of its enforcement authority. I will actually back out here real quick just to pull that language, if I may. So here, again, permit applications are required, including revisions, are required to include the information required by or necessary for DRMS now and the department to make a determination of compliance with C, applicable terms and conditions of the federal coal lease. So the state is plainly empowered by cooperative agreement paragraph 7 to make a determination as part of its permitting process, a determination of compliance with the terms and conditions of the coal lease. And that plainly includes this stipulation, which requires no crossing of a riparian, wetland, or floodplain area unless no practical alternatives exist. And again, there's simply nothing in the record that explains why this crossing of South Prong Creek and its floodplain and riparian area is necessary, given that there are previously approved routes that do not cross that creek. You will note from all the way through here, none of that creek is crossed by any of those black dashed lines. And in fact, it appears that an effort was made to go around the headwaters of the creek to avoid that stream crossing with the prior approved alignment of the roads. So this is zooming in here. And again, you see this dashed line here is South Prong Creek. You see this new road crossing. When again, these could be connected potentially this way or some other route. And again, Mr. Simmons is right that, I was not out on the ground and evaluating this route. And apparently the Forest Service did, but there's nothing in the record that indicates that the Forest Service evaluated whether or not this alignment complies with that stipulation. And it made in fact, a determination that this route was necessary and that there was no practical alternative to crossing South Prong Creek. So with that, I will entertain any questions that y'all may have.
So is your biggest concern the creek?
Yeah, I mean, I think there's a couple concerns. I mean, I think perhaps our biggest concern is the process and the lack of information that's before the division, before this permit revision was approved. The fact that it was approved the same day, the day that the vacatur order was issued, and that there appears to have been no communication from among the division regarding the implications of the vacatur order and what that meant for that legal right of entry. But yes, as a practical matter on the ground, yes, that crossing of the creek is a big concern, which is again sort of the importance of riparian areas in these alpine environments is critical for habitat and all sorts of other reasons. And again, that's why this stipulation was in there. Again, this is a roadless area. There needs to be a really good justification if you're going to have a road in a roadless area. And at this point, we simply don't have that. I mean, even if again, I mean, there's a fundamental lack of a right to build a road in the roadless area at this point, as I think was.
Yeah, we discussed that.
Again, but as far as even if there is an exception back in place, or if we didn't have the legal right of entry question, the North Fork exception only allows or allowed roads that were necessary. And there needs to be some sort of demonstration regarding that necessity.
Sure. I just want you to be careful with your language and how you characterize their operations. You made a comment that said that they didn't decrease the roads out of goodwill. You're right. There's a business reason, lack of reserves, why they eliminated those roads. So I just want you to be consistent with how we present this information factually. If they say they presented this, minor revision due to the lack of reserves, then don't assume that they, don't kind of infer that there was an intention to cross the creek. Let's make sure we're listening to what Mr. Simmons said about, who walks along and makes those maps for the roads.
Right. I was not attempting to imply that there was ill will regarding the creek crossing.
I think when you tell someone that they did not do something out of goodwill, then that kind of sets a tone that's maybe not productive to the overall point that we're trying to get to the bottom of in a succinct manner.
I understand.
Any other questions? Okay, presentation by the operator, please.
Thank you. I'm going to share my screen as well too here. Give me a moment. One second here. There it is. All right, this will not take long. So a couple things, main points in response. The cessation order that the board affirmed today does not preclude approval of MR 446. But the cessation order is a temporary order that they want a showing of legal entry before we do any work. It did not invalidate PR 15. It didn't invalidate any permit terms. Obviously, we cannot do anything in implementation of MR 446 until the cessation order is lifted, but that does not in any way prevent the board from considering and approving MR 446. Secondly, as is clear, it significantly reduces the impacts. Nobody's really arguing about that. Third, as Mr. Simmons pointed out, all the routes, locations, crossings have been field verified by the United States Forest Service, as is customary. Dan Gray, Mineral Resources Specialist, was with Mountain Coal personnel throughout this. Dreams people are always welcome. They were told in advance we're doing these. They're always welcome to attend, but historically they have not, for a couple of reasons. One, because they understand that the Forest Service is the landowner. Secondly, they recognize that the Forest Service is fully competent to determine the appropriate and minimally impactful locations of roads and facilities. And third, there's been a great historical record in terms of those things holding up. I am going to address the question about alternative routes not being, the fact that alternative routes are more impactful and or not practicable. If the board denies the minor revision, that doesn't deauthorize permit revision 15. And so we're in a situation where if the cessation order is lifted, we're back to PR 15. And then we're faced with a choice of either redoing MR 446 or implementing PR 15 as we're authorized to do, which would result in more impacts. And I don't think anybody wants that. You know, it's absolutely correct that we're doing this for business reasons, but we have responsibilities to protect the environment, and we're mindful of those. There's no business interest and there's no environmental interest in doing more road work or more pad work than is necessary to mine this coal. And then finally, an appeal of this minor revision is not really a mechanism to, through the back door, challenge PR 15 or the compliance with the lease terms and roadless area. So real quick here, you've seen this map. This shows what's proposed. I'm going to have John Polos here in a second talk a little bit about why these changes were made. It's because coal didn't go as far in this far quality east as we had thought based upon the exploration we had, but there are also on the ground reasons. Just as the numbers, Mr. Simmons went through this in part. We're reducing road length by over 3 miles. We get 7 fewer MDB well pads, over 13 acres in net reduction in disturbance. And that one thing that Mr. Simmons didn't talk about that I think that we're going to talk a little bit about is there is a significant reduction in cut and fill. So not only is there reduced total length of roads, but the impactfulness of those roads also goes significantly down with this minor revision. As you go through, when you cut roads in very steep terrain, you have to do more cutting of the terrain, filling, supporting, et cetera, in order for that road to first of all hold up and function. And then that increases the length of time that it's then needed to do reliable reclamation. And so the reclamation concern is much greater under PR 15 than it is under MR 446. So here's where I want to have John talk a little bit about. So I want to first ask John to talk a little bit about, you know, you can see, and you can see the very tight contours here. That means there is a lot of surface grade here. And even here, the map never fully captures what's on the ground. When personnel are on the ground, they've got tools they can use to measure the exact degree of grade, and they can see what the condition of the ground is. And so, John, could you briefly describe what was found in terms of the grade as between SS33 and SS32?
As you can see, anytime you cross one of those contours, you're either going uphill or downhill. And as you spoke earlier, if you build a road through a very steep portion of ground, you're going to have a lot more to reclaim and a lot more work to get to that. It also tends to be harder to stabilize, and it takes more work to do that, to make a stable road. And that's the reason why well, you guys can't see my cursor, I'm sure, but that's one of the reasons why the road was moved the way it is now. You can actually see if you go where it says C1364, if you go straight up from the 2 with your cursor, Mike,
Yeah,
go
can
over
you
to the
see my?
2. No, go over to the
Here?
2. Now go straight up.
Yes.
You see where that jog is in the road there? That actually, if you believe the contours, that means we're going uphill and downhill for no reason. My point here is once you get in the field, you find that these contours are not exact. The contours on these maps could have been generated as far back as the 60s. I've seen some of that on topographic maps. Those were made from aerial photos, and they don't actually map the surface. They map the foliage and how that works. So you do have to go into the field in order to understand where is the safest route for your men and equipment to work. If you want to move down to SS3, you can see how the lines go back and forth and back and forth and back and forth. Those represent switchbacks. And I think we're all familiar with what a switchback is. Switchbacks are very hard to build. They're very dangerous to try and maneuver long drill rigs around. And the short road that you see from SS3-1 down to SS4-2 chases the contours. And that was found to be the best and safest route to eliminate all those switchbacks on steep terrain. And therefore, that's why the changes were made in the field in conjunction with the Forest Service representative. My drilling engineer and Dan Gray go to the field together, and these roads are laid out with both of them concurring.
And John, could you say something about what kind of grade you found, what the percentage grade you found in this area?
Well, it was upwards of 20%, if I'm not mistaken, which is extremely steep, especially when you're trying to move heavy equipment, wheeled heavy equipment.
And what about between SS43 and SS42?
Well, you can see that what we estimated several years back with PR15 as to what that route would be. Those are, I believe, 100-foot contour intervals. Every one of those is every time you cross the line, you've gone another 20 feet. So the grades are extremely steep. Again, the changes in these roads were made in the field based off actual field conditions, not necessarily the tops of the trees that get mapped when you do an aerial photo.
And did you guys also consider as an alternative for SS3 going up here where the grades are a little gentler and then coming down this way?
We may have, but you're still crossing those roads. There's a lot of glacial till or colluvium up in there, and you need to pick your spot to get across those benches in a safe manner. Some of that area is prone to sliding and slumping, and that's taken in consideration when the Forest Service representative and drilling engineer flag these roads.
So ultimately, what they found was very steep grades between SS33, SS32, grades between same thing, SS43 and SS42, too steep, too dangerous, and too impactful as compared to alternatives to do the drill regs. They looked at shifting the road north. You got a surface area that's marked by slides, poor stability, and highly uneven. Now, and then finally the issue of the crossing. What's your understanding of the degree of flow in the crossing at that location, John?
Well, we checked it yesterday. Actually, there was some photographs taken yesterday. There is no flow in that branch of South Prong Creek.
And so collectively, they examined it carefully. They looked at it. They determined. I'm going to stop my screen share here. And so forth. So this is really, so in summary, this is, there were strong reasons that everything was done according to normal course here in terms of having the Forest Service review, sign off on this. There were sound reasons for the relocation of the roads. The argument that these are new roads is really, again, semantics. The issue on roads is, do they access the same places, the same areas for the same coal work? And that has not changed. It is a relocation within the meaning of the temporary revision rule. And, you know, on the legal right of entry issue, that's going to get resolved one way or another. If we never satisfy the agency that we have legal right of entry, we won't be able to implement any of this, and it's going to be moot. If we do, then we're going to be able to do this, and that should not stop the board from approving a revision that is very significantly improving in terms of environmental impacts from what was originally approved.
Thank you for that. Any comments or questions from the board? Questions from the division before we get into rebuttal? No? Okay, let's proceed with rebuttal from the division, please.
There we go. Hey, ladies and gentlemen of the board, this is, oh, let me shut off my microphone here. Jason Music with the division. Just a few things that I'd like to touch on. It was mentioned in testimony. The first would be the kind of the chronology of this minor revision. It's not unusual for minor revisions to be turned over in this way, which is why they're minor revisions. A minor revision can be found complete, adequacy could be done, decision could be done all the same day, which this one was. But I don't want the assumption to be out there that there wasn't discussions internally with the division as to what was going on. As Mr. Timmons testified to, yes, we were aware that there could have been a decision coming down. However, we can't kind of stop our decision-making process in order to wait for certain determinations that may be coming down. Simply because the ruling was issued at 8:35 a.m. doesn't mean that we received that ruling at 8:35 a.m. And even if we did a decision by the division to make that legal determination of right of entry was not adhered to, was going to be made after this minor revision was made. So in terms of the minor revision, everything associated with that minor revision that made it approvable, including one adequacy item that Lee Simmons noted, was addressed. And so once that is done, the division issues its decision. So I just wanted to make that kind of clear that I didn't want the assumption to be that there was some miscommunication internally, which there definitely wasn't. And I just wanted to kind of echo Mr. Polis's testimony on the layout of the roads. They know this site the best. It's kind of similar to a construction site where you have certain plans, and this was the case with PR 15. A PR 15 was submitted with roads and pads delegated in certain areas that were determined on a map. But you have to get out, you have to ground truth these things, and which is what Mountain Coal does with the Forest Service. I mean, they are out there, I mean, much more often than we are, and we're out there once a month. So they have to ground truth them. They find the best locations to meet their mining plan, to meet the requirements of the Forest Service. And that's why these roads get changed. Our job is to receive a revision that identifies those changes. And then we make a determination based on that revision, which is the case with the 4 previous MRs associated with this. So this isn't unusual. This MR is as straightforward as it gets in terms of coordination with the mine, coordination with the Forest Service, in terms of surface conditions, and us. And I also want to reiterate that, you know, like I said, we have a member of the division out there in terms of monthly discussing this stuff. So it's not, we're not in the dark on this. Lee is out there. He knows what's going on. If they say, hey, we're going to submit a minor revision, it's going to change locations of pads and road. Lee has his series of questions. He's the one permitting it. They answer his questions. He tells them what they might need to submit or what they might not, and they submit it. And so it's not as if a minor revision shows up out of the blue. We turn it over in a day and wash our hands of it. I just want to make that kind of clear as well. And that's all I have on rebuttal in terms of previous testimony. If there's any questions on that, I'm happy to answer them.
I don't see any questions. Anything else on the rebuttal from the division? No. Okay. A rebuttal from the conservationists, Mr. Timmons?
Thank you, Madam Chair. So it's hard for me to respond directly to the presentation that Mr. Drysdale put on because all of that information is brand new. And as far as we can tell from the record, none of that information was before the division when it made its decision to approve this minor revision. There was nothing, again, that narrative description that was before the division basically said, we want to change the location of these pads and roads. There was no explanation of why it was necessary. There was no discussion about significant cut and fill issues. There was no discussion about the steep topography. And so I believe that the decision needs to be evaluated on the information that was before the division. We can't, it's unreasonable to expect the public who is trying to keep apprised of these situations to basically get access to that individual map and that brief narrative description and to recognize what the conditions on the ground might be. So I think that and again, there's nothing in the record to indicate that those ground conditions, whatever they may be, were in fact communicated to the division before it made its decision. So the fact that we're sitting here hearing testimony that was not before the division at the time of its decision is really problematic. And it's essentially looking to backstop a decision that was not supported by the information that was before the agency at the time. And again, the discussion of the riparian area, I mean, it does sound like that there were better or easier, that going through the creek, South Brown Creek, was a preferred route for the company. I didn't hear it clearly articulated that it was not practical to not cross that creek. And again, that's the language, that's what's in the stipulation, that demonstration needs to be made. And certainly before the agency at the time, based on the map that was provided in the limited narrative description, the agency had nothing to support a determination that it was not practical to go elsewhere. And so that's, I believe that that's the decision, that's the information that's before the board at this point. And essentially this is sort of post hoc rationale that is being offered here to backstop a decision that was already made. And so we would just ask you to look at the information that was in the record and before the board or before the division, and make a determination whether or not there was sufficient information for the division to determine that those road alignments were needed and that it was not practical to avoid crossing a critical riparian area. Yes, there might not be flow in it here in the high summer, but again, this that doesn't mean that it's not still valuable riparian habitat that provides significant wildlife benefits and other downstream water quality benefits. So again, there's a reason that every effort needs to be made to avoid crossing a creek if you can. And simply a demonstration that that effort was taken, I do not believe is in the record before the board at this point. I'm happy to take any questions.
Mr. Timmons, just for clarification, so you felt like it wasn't in the record, this map and this conversation about cut and fill. Are you asking the board then to ignore the presentations?
It's not a question of ignoring the presentation. It's a question of evaluating the appropriateness of the decision that was made. And so to the extent that, yes, this is new information that's being brought to sort of backstop this decision is problematic. Because it sort of is, again, is a approved, I mean, it appears like the permit revision gets approved. And then if there's a challenge, then you can come back and justify it, as opposed to actually having the division make an evaluation based on the information that's presented to it at the time it makes its decision.
The permit revision or the minor revision?
The minor revision, yeah. I mean, I think it's very clear that we are not challenging the minor revision. I mean, I'm sorry, we're not challenging the permit revision. We are challenging the changes that were made in this minor revision. And in particular, the new alignments that connect areas that were not previously connected. And so that's, those are in particular the areas where it seems appropriate for the division to take a look at that and actually evaluate, make a determination whether or not those roads are needed and whether or not that stream crossing, which again, that stream crossing was not approved as part of PR 15. That was only approved as part of this minor revision. So that appears to be a substantial change that needs to be evaluated and evaluated based on the information that was before the division.
Okay. So you wanted to have this heard before the board because you wanted further information, further narrative, further understanding on the issue, and you wanted to hear that, correct? Have that discussed? I guess I'm confused how you're asking for us to hear this and discuss it, and yet you don't want us to take into consideration narrative about why they changed the roads, and you're kind of saying that that's not part of the record. When I guess, you could just come out and you're either saying that there's not enough information in the permit, the computer permit side of things, because you showed that very small sentence and you felt like there wasn't enough color to that. At the very beginning, Mr. Simmons said that a minor revision stands, unless there is significant work that alters the reclamation. Is that correct? Just generally? Yep, generally a minor revision goes through and it typically is approved based on the other ones unless it, flags a really significant reclamation change.
Yeah, unless it proposes significant changes to the reclamation plan.
Yeah. Okay. Thank you. Mr. Drysdale, are you doing rebuttal or having a comment about this part of the conversation right now?
Whichever, I can wait.
I want to just make sure this discussion is good before we move on to your rebuttal. Does anyone else have anything to say? You okay? We'll hear a rebuttal from the operator, please.
Yeah, just briefly, Madam Chair. I think you hit the nail on the head here. I think what the conservation groups are doing is confusing this with a record review action as you might have in a court of law, where the agency has made a final decision and then the court is bound to look only at the record that was in front of the agency at the time. This is an internal administrative proceeding. The Sea Dreams felt it had enough to make the decision. The appellants, the conservation groups challenge that, as is their right to do. And this is an opportunity to provide further information so that the board can make a decision. Otherwise, there's no purpose in having sworn testimony by witnesses who are available. So the conservation groups were entitled to cross-examine Mr. Poulos. They were entitled to bring their own expert if they had a different view. And it's just the nature of the proceeding. So I think that the procedural objections on that front are not well taken. And that's all I have, Your Honor.
Thank you. Any questions? Okay. Closing statements from the division.
Jason Music again with the division. I think unfortunately, it just seems like the entirety of the conservation group's testimony is just a lack of understanding of the division's process in permitting, quite frankly. Like I said, this is a minor revision for a reason, and it's a minor revision number 446 for a reason. You know, that's a lot of revisions. That's literally the most minor revisions for any mine site that we have in the state. This isn't an action that the division shirks, basically. We don't dictate mine plans. We don't dictate what the operator is required to do on the ground per their business plan. We receive a revision based on what they determine is the best course of action for them, and we review it with our acting rules. And then we enforce it on the ground through inspections. And so if they say that these roads are in the best possible locations they can be for their mine plan, we're going to jump into our act and rules and we're going to make a determination if that's the case. And that's what we did here. And it's not unlike any other minor revision that we've done, as Lee pointed out, in the Sunset Trails area associated with PR 15. So I just wanted to make clear that the division's actions are an open book. You know, everything's public knowledge, but I also want to make clear that we have good collaboration with federal agencies associated with the site and the operator. And we're aware of everything that's going on the mine site. So that of course dictates our decisions as well. So they know what they need to submit and we know what we need to approve and review. And I think that'll close the division's testimony.
Thank you. Closing remarks from the conservationists.
Thank you, Madam Chair. To start with the legal right of entry question, I think it's very straightforward. If there is not a demonstration of a legal right of entry, as this board has determined, then the permit revision cannot be approved. That is one of the requirements for a permit revision. Yes, this is a minor revision under the regulations, but that is still a type of permit revision. There are new locations for these roads that have been approved. That is a revision. There needs to be some assessment of compliance with the statutes and regulations, which require a legal right of entry. So to the extent that we don't understand the process, I think that's because we have assumed that the division was evaluating this and making a determination about compliance with legal requirements before it was approving these permits. What I've heard from Mr. Music here is that the division was willing to or are ready to approve roads based on the company's determination of the best location of those roads from the company's perspective. And that is simply not the standard. The standard here is that the roads have to be necessary, have to be needed to meet the roadless rule requirements. And there has to be no practical alternative for crossing a stream, a riparian area, and its floodplain. And that demonstration has simply not been met. We've heard that there are better routes, that there are easier routes, or that, I'm sorry, that crossing the stream is better for the company and is easier. But we have not heard that it is not practical to not cross that stream. And yes, there have been 446 permit revisions. There, I believe, are only 5 to 7 stream crossings here, because stream crossings are a big deal, and there needs to be a real look taken at that. And from what we have heard, that just simply does not appear to have occurred. So we would ask that you vacate approval of minor revision 446. Thank you.
Thank you. Rebuttal, or I mean, closing statement from the operator, please.
Yes, just very briefly. I think the illegal right of entry question has been addressed. As to the practicality question, again, you've heard testimony that nobody's really contradicted that says that continuing with the roads that are that were approved by PR 15 increases environmental impacts, increases reclamation time and cost and reliability, increases danger, et cetera, and significantly reduces surface impacts. You know, the conservation groups seem to be at war with themselves on this, in that they've emphasized at all times the need to minimize surface impacts, and this is a proposal that does that, and yet they're contending that it can't be done because of other issues. So I think that both the division and the mine have made the demonstration necessary to allow this to be approved.
Thank you. Questions directly into deliberation. Chuck, let me know if I'm missing something here. Next steps.
Yeah, if the board doesn't have questions for parties, then close testimony and move to deliberations.
Okay. Any questions from the board for the parties? No questions? Okay, we will close testimony and begin deliberation. Is everyone still thinking, letting this soak in?
I'll go Tim Mock here. I think this minor revision is straightforward, and I'm not moved by the objections that have been raised, and I intend to support the division's decision to approve MR 446.
Thank you. John?
I would make a motion to approve the division's decision on minor revision 446.
Would someone like to second?
I'll second.
Karen seconds. Any discussion? All those in favor, please signify by saying aye.
Aye.
Aye. Those opposed, same sign. Hearing none, the motion passes. Thank you. Okay, thank you everyone for your time today. I want to make sure there's no public comment. We have that on the agenda.
I've got nothing. Nobody's come to me.
No public comment?
Nope.
Okay. Well, with that, we will adjourn. Thank you, everyone.
Thank you.
And thank you.
Thanks, everyone.
Have a good night.
Thank you.
Good night. Good afternoon.